if it's not inconvenient to your lordship, may I pray for upgradation of item number 22, if not inconvenient, my lord. This is regarding wrong fixation of pay as per ROP 2017.
Okay, we'll see
Lords,
if we can take it up.
Lords, oblige me.
Meet with your lordship. Similar prayer in item 24, lordship. I am for the respondent and I have taken consent from the petitioner's side, lordship. 2008 judgment, in fact, RFA was filed thereafter, it was withdrawn, then writ petition, but it was converted to CRP. And suit is of 1996, lordship.
Okay, we'll take it up at 2.
Lordship, deeply obliged. And lordship, 2 orders matters, lordship, for service report, any date.
Hmm?
2 orders matters, 2 RSA order matters, lordship. For service report, only notice was sent long back, 3 months ago, lordship. So can it be on?
Service complete.
No, lordship, just to know whether service complete or not. We have
Find it
taken,
out from the registry.
lordship, by checking.
No, from the registry, find it out whether the service is complete.
Lordship,
Whether the service is complete, then get the matter listed. Otherwise, this makes no sense.
lordship, obliged.
Motion item 1.
Apology, Lordship. Lordship, may kindly take up this matter after some time, Lordship. My senior Mr. Edgecombe has got stuck in the traffic jam, Lordship, due to heavy rainfall.
Huh?
He got stuck in the traffic jam, Lordship, due to heavy rainfall, Lordship. Lordship, may kindly take up this matter after some time, Lordship.
This is the same order I passed.
No, Lordship, there is something different, Lordship.
You are stenographer grade 2.
My lord, I'm grade 3.
Then what is there wrong?
My lord, only thing is this, my lord, that as per advertisement notification, that 5 years experience is necessary. Either stenographer 3 or stenographer 2. The private respondents, none of them completed 5 years.
Who?
Either as respondent number 3, as the stenographer 3 or stenographer 2. So they are not eligible for the post. That advert notification, my lord, your lordship will turn to page 41.
Yes.
So, my lord, for eligibility criteria for promotion to stenographer 1, completion 5 years of service as stenographer grade 2 or grade 3. My contention before your lordship is this: none of them, private respondents, 4 private respondents, my lord, who are selected among the 17, neither of them completed 5 years as a stenographer 3 or stenographer 2. So in eligibility criteria, they do not cover, my lord. Their application was not to have been accepted by the authority. And your lordship, in the meantime, state this impugn notification. That impugn notification, what I impugn, my lord, that has been stated by your lordship in WBC number 2325 of 2025.
We'll issue notice here
Yeah,
and take this matter with the.
yes, ma'am.
22nd
That will do.
May, Lordship has taken this matter.
Yes.
Not 22nd May. 22nd May?
No.
When is the next date?
My lord,
22nd May,
by
Lordship.
22nd, my lord.
You take this along with that. You bring on record your affidavit and bring the records. We'll finish it off on 22nd. Here, the question of stay does not arise because I've
lord,
already.
already
Your
stated,
Lordship
my
has
lord.
already stated the notification.
It was returnable by 22/5,
Yes.
2025.
Okay, issue notice making it returnable on 22/5/2025.
25.
Mr. So-and-so accepts notice on behalf of the respondent number 1.
One technical difficulty is there, Lordship. Perhaps Lordship register admin is
Mr. T.R. Gogoi accepts notice on behalf of the respondent number 2. To serve extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 3, 4, and 5,
5 and 6, my lord.
5 and 6, extra copies of the writ petition be served upon Mr. So-and-so, who appears on behalf of the Guwahati High Court, so that the Registrar General of the Guwahati High Court is in a position to effect service upon the said private respondents. First, the Registry of the Guwahati High Court shall submit a report as regards service upon the private respondent number 3, 4, 5, and 6 on or before the next day. First, the petitioner herein, who is a grade 3,
Grade 3, madam.
the grade 3 stenographer. And he is a stenographer grade 3, has approached this court challenging the appointment of the private respondent number 3, 4, 5, and 6 on the ground that the said private respondents do not have the requisite eligibility, taking into account that they have not completed 5 years, either as a grade 2, as a stenographer grade 2 or a stenographer grade 3, even if put together.
Yes, ma'am. No, my lord, if put together, then all right.
Then what is your case?
My lord, it cannot be, my lord. Your lordship would be pleased to see either grade 2 or grade 3. Both cannot be taken together, or it is not and. Page 41, my lord. If it is taken together, then all right, my lord. But if grade 3, they have not completed. At grade 2, they have not completed. It is not taken together, my lord. That is my humble opinion.
As grade 2 or grade 3?
Yes,
Sir, may I just clarify one thing? You know, this matter is different from that matter.
Huh?
This matter is different from that matter. Because this is grade 3. Eligibility list was published. He was a beneficiary of that decision in the resolution. He has not been promoted to grade 2.
No,
This
no,
petition.
no. I know that is different. But taking into account that this court is already taking up that issue. Just
Yes,
for example, if I decide that writ petition
yes,
in favor of the petitioners therein,
yes,
his petition becomes bad. He's a grade 3.
yes,
His petition becomes dismissed. I have to dismiss his petition.
yes.
Okay.
That is there.
Now, if I hold it against the petitioner therein, thereby saying that it can be permitted, then the question will arise as to whether it is grade 2, 5 years or grade 3, 5 years together, or can it be taken combined? That is his issue.
But his issue is that that is the issue, but the attending facts while raising that issue is that, my lord, the private respondent, the petitioner claims that the private respondent, when they got appointed as grade 2, that was a process of direct recruitment. So he is trying to say that they resigned from grade 3 and joined grade 2. So since they joined grade 2 in the year 2023, so they do not complete 5 years of service. But if we go by the,
Mr. Das, I'm not going to stay any. I'm
Then
not
fine,
passing-
Mr. Then fine.
I'm not passing
Then
any time.
then fine. I was
No, I'm
Yes.
not passing any time. I'm taking this matter along with that.
fine.
So
No
that
problem.
you bring on record their status. and
Absolutely,
bring on record.
absolutely.
The case of the petitioner herein is that the petitioner, who is a grade 3 employee, a grade 3 stenographer, have completed 5 years, whereas the private respondents have not completed. Five years, either in as grade 2 stenographer or grade 3 stenographer. First, taking into account that the challenge to the notification dated 22/4/2025 is already as subject matter of a writ petition being WPC number
WPC number 2325
oblique,
2025.
comma,
2325.
list the instant writ petition along with the said writ petition on the returnable date. Full stop. In the meantime, the respondent number one, as well as the private respondent number 1 and 2, as well as the private respondents, shall bring on record their stand by filing their affidavits on or before 19th of May 2025. Full stop. The petitioner, if so advised, will be at liberty to file the reply by on or before the next date.
All right.
The records of the proceedings we also produced on the next.
Right.
Petition.
For admission, item 2.
So this matter relates to completion of appointment. Lordship, may kindly peruse the last order, Lordship, on 23.
Yes, affidavit filed.
My lord, I need some more time. My lord, what happened, my lord? We have written to all district establishment. And we have not received all their instructions. So, 3 weeks time will be given.
Are you saying that the Guwahati High Court does not know how many posts are there in the LDA and grade 4
In,
in each of the establishment?
how many posts are lying vacant?
I'm not lying vacant. The Guwahati High Court does not know when you are having a centralized recruitment process. Are you saying that?
My lord, that is my
You
instruction.
impose a cost of 50,000.
My lord, only kindly consider one.
No, nothing doing.
My lord,
We'll
kindly
ask the
consider-
personal appearance.
consider
This
one
is,
thing,
this
my
is absolutely, don't come up with these type of excuses, Mr. Bush.
My lord, there is absolutely no excuse, my lord.
Then
I have received only 2 instructions from.
I'm not concerned. Are we to know that the centralized, isn't there the recruitment done centralized? For grade 4 and grade 5, LD and NA, is it not done grade 4?
Establishment wise. My lord, kindly see, the CGM, Hemaji, he wrote the letter after the receiving of the compassionate appointment application.
Are you making a statement that it is not done centralized?
My lord, I have to take instruction on that.
No, not if you don't know, that you have been a counsel for the High Court.
My lord,
Isn't it the Renu follows? The judgment of Renu does not apply to Guwahati High Court.
my lord, my lord, otherwise also, the Dulu Dottot squarely applies in this case. The petitioner for the first time applied in 2023, whereas we have banned the compassionate appointment in 2018. Man. That was not placed by the petitioner. Man. It was the drafting is done very intelligently, my lord, for the first time, the petitioner applied for compassionate appointment in 2023. Whereas this order came into force in 2018, my lord. Kindly peruse the application of the petitioner, which is at annexure 8, page 49, my lord.
Page 39.
Page 49, my lord.
If that was known, then why did your register administration have written the letter at page 59?
My lord, yes, my lord.
Why?
I'm highly aware.
My lord, uh,
Secondly, are you saying now, because this has a very big double-edged sword, are you aware what you are making the submission? You will be happy. What was the age of this person when he died?
17.
Huh?
17, man. 17, man.
No. Your father?
Father 53, my lord.
53. Retirement age is 60.
60,
60.
60.
Okay. Have you paid him the last drawn wages as per the 2023? Are you saying that? As per the 2017 office memorandum, are you going to pay him the last drawn wages? Are you aware of that?
Not, as per 2017 memo.
Now have you paid him? Don't make that submission. Has a much bigger financial implication. You want to give it, give it. I will record it. I will record it. Then
My
file
lord,
your affidavit.
on that I need,
No,
I
I'll
cannot say
record
that,
it.
my lord. I
I'll
cannot,
record it. Now I'll take it. Don't worry. He will be happy also. Get that money. And it is your submission. You take it. Leho.
my lord, the
No.
father of the petitioner expired, kindly,
Yes.
listen, man. Father of the petitioner expired in the year 2016.
Okay.
Thereafter, the mother applied for. Kindly see the chronologically, my lord. Father of the petitioner died on 9/7/2016. Then on 12 October 2018, the mother applied for compassionate. Then, my lord, what happened? In 15/12/2020, the petition was rejected. Her, her application for compassionate appointment was rejected. Kindly come to annexure 4, page 30,
Page.
page 30, my lord.
30 also.
My lord, kindly peruse the subject, man. Appointment of
There is no
compassionate,
vacant post. That
Eh,
is the reason why I have asked you to
My-
file affidavit.
my lord,
That is the specific reason why I have asked you to file an affidavit. Now you are submitting about this document. Then we'll take it.
my lord, what I'm saying,
Moment
my
you are
lord,
submitting this document, you mean to say that this 2017 the office memorandum will be applicable insofar as the petitioner is concerned. So therefore, the petitioner would be entitled to the last drawn wages for all this period from 2016 onwards, when that particular office memorandum was not holding the field, till he attains another 7 years down the line.
That's what I didn't mean.
So don't
I
make-
meant that
don't make
for
this
the,
submission.
for the first time, the petitioner filed the compassionate appointment application in 2023, when the bar is there.
So are you going to give him this?
No, my lord.
Then-
But on 2023, after 7 years, what survived, my lord? Is it delay, negligence, my lord? And the Dulu Datta and Tiwari case is.
Then
very
why
excellent.
on earth you did not say that in your page 59 order? In page 59 order, you say that there is no vacant post. Then
That I cannot improve.
no, you cannot improve that. So
My-
therefore,
my
I
lord-
asked you the specific to submit, and now you are saying that the centralized, the government, the Guwahati High Court does not do a centralized here for grade 4.
I will file an affidavit to that effect. Let me file that, my lord.
You file your affidavit. I gave you 1.5 months time.
I don't want that much time.
I gave you. You don't want is different. I have already given you.
My lord.
I gave you on
Some more-
23, 2025.
Yes, man.
Okay.
Some more time, my lord. may
Last
be given.
chance. I'm giving you the affidavit to file by today is 15th. Else a cost of 50,000 will be imposed.
If I fail. My lord. One more week, my lord.
No. You say you are going to file it today.
No.
Just now you say.
No, not.
No,
today.
you didn't say.
No, no. I
Mr.
did
Counsel,
not.
didn't he say? Yes.
No, I did not. my lord.
Yes, you did. Let us record it.
My lord,
Don't make that statement, Mr.
Well,
Mr.
I did
Bushra.
not
You have to be
mean it.
very careful when you are appearing before this court.
I did not.
Don't
mean
come
it,
up
my-
with this type of statements. Don't come up with these type of notifications. You say this notification would only be applicable of those persons who die after the
After.
notification. Then why on earth did you bring this notification?
There are Supreme Court judgments also, Lordship. Supreme Court judgments are also there, Lordship, which says that the scheme prevalent at the time of the date will be applicable, Lordship. Just there.
You should have come up with the thing that where is the question of compassionate appointment
my lord.
now, taking into account that these are the things, but that is not your issue.
Can it be on 22nd? my lord?
No, not 22nd. I
As your
understand.
lordship, please, man.
This court had already granted time to the Guwahati High Court to bring on record an affidavit by an order dated 23/2025 as to how many posts are vacant in the cadre of the lower division assistant direct recruitment or grade 4 direct recruitment in the principal seat as well as in the entire district establishment of the Assam, which can be filled up by way of compassionate appointment in terms with clause Roman 17 of the scheme for compassionate appointment for Guwahati High Court, principal seat and district court establishment of Assam notified by notification dated 3/1/2017. Full stop. It is relevant to take note of that the father of the petitioner had expired in the year 2016. Mr. G. Busher had submitted that as on the date on which the petitioner had submitted the application, that is in the year 2023, the said scheme of 2017 was not applicable, taking into account the notification dated 19/4/2018, whereby it was mentioned that the scheme of the government, as per the notification dated 14/9/2017, for compassionate family pension in lieu of compassionate appointment would be applicable. Full stop. Full stop. taking into account the said notification, which have been placed by Mr. G. Boisho, the learned standing counsel of the Guwahati High Court. This court inquired as to whether the Guwahati High Court now is willing to give the benefits to the petitioner or the mother of the petitioner in terms with the notification dated 19/4/2018. He submits that he will take instructions in that regard. Pusto. List this matter on 22nd of May 2022-25. In the meantime, the said instructions be put on affidavit and be filed on or before 19th of 2025. Pusto. It is observed that if no affidavit is filed, this court would presume that the submissions so made by the learned counsel standing counsel appearing on behalf of the Guwahati High Court to the effect that the notification dated 19/4/2018 would be applicable. Is the stand of the Guwahati High Court. You don't file, you know the consequences. It's not even 50,000. It goes in lakhs.
Item 3,
Yes.
So we have challenged the selection process to the postal process server, which was initiated by advertisement at page 17.
Page?
17 is the advertisement.
Hmm.
It was issued on 2nd of January 2024. The qualification which was prescribed by the advertisement were having minimum educational qualification of graduation for filling up the post of Jari Karat, and he should be employee working under the establishment of the district and session judge. The two qualifications which was prescribed by the advertisement. Petitioner and the private respondent applied.
Then
Also, page 18 is the result.
what is the name of the petitioner?
Tapas Bharadwaj and Namita Das, two petitioners.
Nomita Das. Nomita Das got 36
Gotcha. And
and
Tapas
you
Bharadwaj
got
51.
51.
Tapas Bharadwaj, that is petition number 1, Lord.
Then
And selection was given to number 4, that is Navajyoti Handy, who secured 53.5. Our contact-
oh, he was a driver, contractual. So he cannot be.
Yes,
So we have to set aside the entire thing.
Lord,
That was the case.
Also wanted the records, my lord, I have just.
I remember now.
This was absolutely neither here nor there. If you want to fill up it by direct recruitment, then keep it open for all. And if we go by the advertisement, it appears that it's a promotion. If it's a promotion, my lord, then there has to be someone born in the feeder cattle.
You find the affidavit? No.
The records is there. It says that he was walking, so that's why he was called. The instructions basically say.
Are the traditionally species of the employees of
There is a notification. Draft one.
So your case is that as he was a contractual,
Yes, Lord, he's not an employee.
he cannot be considered to be an employee working under the establishment of the district and session judge. That's your case.
Lying on the gradation list of, which was published on 1 day prior to the advertisement. That is 1st January 2024, a gradation list was published, which is at Annexure 7, Lordship. Page 24. The name of the private respondent does not appear.
Page?
Page 24, Lordship. The gradation list of grade 4 staff of district and session judge establishment Sibsagar as on 1/1/2024, 1 day prior to the advertisement, Lordship. Name of the petitioners appear at 18 and number 20. The name of the respondent number 4 does not appear, Lordship. Basically, even the establishment doesn't recognize
Heard
him to be
Mr.
employee.
D. Dekar, the learned counsel appearing on behalf of the petitioner. Mr. H. K. Das appears on behalf of the respondent numbers two and three. Mr. T. R. Gogoi appears on behalf of the respondent number 1. Mr. So-and-so appears for the respondent number 4. Full stop. The petitioner herein, who is a grade 4 employee working in the establishment of the district and session judge Sibsagar, have assailed the appointment of the respondent number 4 to the post of Jarikarak public process server in the establishment of the district and session judge Sibsagar. Full stop. The ground on which the petitioner has approached this court is that the respondent number 4 brought within the zone of consideration in terms with the said advertisement dated 2/1/2024, in as much as the respondent number 4 was not a grade 4 employee working under the establishment of the district and session judge Sibsagar on the date on which the advertisement was issued. First, this court have duly taken note of, first of, to ascertain the legality, to ascertain the merits of the case of the petitioner, this court find in brief would like to take note of the facts which led to the filing of the instant petition. First of, the petitioner herein, the respondent number 2 herein has issued an advertisement dated 2/1/2024 inviting applications from eligible grade 4 employees working under the establishment of the district and session judge Sibsagar having minimum educational qualification of graduation for filling up of the vacant post of Jarikarak process server in the establishment of the district and session judge Sibsagar. Pursuant to the said, the selection committee, that is the respondent number 3, selection board, that is the respondent number 3, conducted a selection process, and in the said selection process found the respondent number 4 to have obtained the highest marks. And as such, the respondent number 4 was appointed. Be that as it may, it is relevant to take note of that even in the minutes of the selection proceeding, it has been duly reflected that the respondent number 4 was only a contractual appointee and appointee. This court have also taken note of the gradation list of grade 4, which was published, grade 4 of the district and session judge establishment Sibsagar as on 1/1/2024. Wherein also the the petition, the respondent number 4 does not find his name in the said list. Full stop. The learned counsel appearing on, full stop. Pursuant to the, no, no, be that as it may, pursuant to the said selection proceedings, comma, the respondent number 4 was duly appointed as a Jarikar by an order dated
21/3/2000. That is at Annex 3, page 19.
by an order dated 21/3/2024. And it is under such circumstances the petitioner has approached this court. Full stop. During the course of the hearing, Mr. H.K. Das has produced before this court the records of the selection proceedings, wherein it is seen that all the other candidates, including all the candidates who participated in the said selection process, including the petitioner, had submitted representation, which were however rejected by the respondent number 2. Full stop. The respondent number 4 had also filed an affidavit in opposition, wherein the standing is that if the respondent number 4 was not eligible, why was the respondent number 4 allowed to participate? Full stop. In the backdrop of the above, this court have duly perused heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Full stop. The materials on record, as well as the advertisement so issued, more particularly the advertisement so issued on 2/1/2024, makes it clear that the said post, that a vacant post of Jarikarok public process server is required to be filled up, would be filled up by way of promotion. Isn't it?
Yes, language, my lord, implies that, my lord.
Of promotion. Full stop.
But if your lordships see the records, the way selection has been done, written examination, interview, and so on, so on, so on.
But if it was direct recruit, then it has to be pasted out there. This is not
the-
given.
It has to be open for all.
Uh,
It cannot be establishment wise.
Advertisement shows, perusal of the advertisement shows that the post of the Jarikarok public process server was sought to be filled up by way of promotion, more particularly in view of the language used, inverted comma, from intending eligible grade 4 employees working under the establishment of the district and session judge Sibsagar, inverted comma, close. First, the fact that the respondent number 4 was not a grade 4 employee working under the establishment of the district and session judge Sibsagar as on the date of the advertisement, or even at the time of when the selection proceedings were conducted, is not in doubt. First, considering the above, the selection of the respondent number 4 in the said selections held pursuant to the advertisement dated 2/1/2024. Not only is in violation to the advertisement dated 2/1/2024 itself, but it also violates the mandate of Article 14 and 16 of the Constitution, inasmuch as the respondent number 2 and 3, on one hand, had taken steps to fill up the post of Jarikarok / process server from the in-house candidates, but have taken into consideration the candidature of another candidate who is outside the establishment of the district and session judge Sibsagar, thereby depriving the other eligible candidates who could have otherwise participated. Considering the above, this court sets aside the appointment of the respondent number 4 by the respondent number 2 in pursuance to the order dated 21/3/2024. Further to that, this entire selection proceedings also stands vitiated, having taken into consideration a candidate which is outside the zone of consideration. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The appointment of the respondent number 4 by the order dated 21/3/2024 issued by the district and session judge Sibsagar is set aside and quashed. Number 2, the appointment of the entire selection proceedings held in pursuant to the advertisement dated 2/1/2024 is also interfered with. Number 3, the district and session judge Sibsagar shall take appropriate steps for filling up the post of Jarikarok / process server in accordance with law.
Item 4.
The photocopy of the records which have been placed by Mr. H.K. Das is kept on record and marked with the letter X. Was there any stay?
No, Milord.
No, no. The appointment was subject to the outcome of the.
Subject to the
petition.
outcome.
So then in that case, would there be any recovery?
There should not be, Milord. Normally, they don't do.
Hmm?
Lots
Because
of-
he has, it's an illegal appointment, then no recovery, no?
But
Should
normally
I
they
protect
don't
him?
recover, since they have worked and they have got paid because of they work, he worked. Now, I don't think, Milord, after termination, that will be, Lordship may observe something. Milord. But normally that is not done, Milord.
But if I observe, I will be regularizing his period.
No, it's not required. Till today, till the date your Lordships interferes, that appointment is valid, Milord. So he got.
Okay, Mr. Das, what is the?
That's it.
Your matter is over.
My lord. With seniority come merit, man.
What is happened?
Lordship will kindly see page number 47. A resolution was taken by the, my lord, CJM establishment Hosai for filling up of 2 vacant UDA posts, my lord. And by that resolution, my lord, it was held that, my lord, the total marks for the
First, let us see how, well, your appointment
Yeah.
on
promotion, my lord, from LDA to UDA.
where?
Page number 47.
Please, Kevin.
This is the resolution.
You are, what is your name?
At 48, my lord. Serial number 2, Kobita Bora. She
You are
joined in the year
Kobita Bora.
2013.
Okay, then who have been promoted?
3 and 4.
Anupam Paul and Anirban Bose.
Yes.
Okay.
Now, the total marks for the interview was fixed at 50 and the pass mark was fixed at 30. And the petitioner, my lord, marks it is at page number, my lord, 52,
Page
52.
two,
He got, my lord, 29.33 out of 30.
29.33.
33.
Oh, you did not?
Yes, but our case is simple, my lord. In case of, my lord, seniority cum merit, my lord, to determine the merit, an interview is permissible. But the minimum merit should not be kept so high that, my lord, indirectly it is a case of, my lord, merit cum seniority. That has what has happened in this case, my lord, because 30 out of 50 will be 60%. And in that regard, my lord, I'd like to rely on a judgment, my lord, where, my lord, Supreme Court said that in that case, my lord, 75% benchmark was too high,
Here they have put it 60.
60%.
Then,
In Sivaya, it was 50%.
then
So
Sivera, is it bad?
if we keep
No,
Sivaya,
in Sivera, is it bad?
no,
Sivera, 50 is okay, it has been said.
yes. Here it is 60%. Well, normally pass mark should be minimum 35%. But if it is so high that 60% is the pass mark, then, my lord, indirectly it's a case of, my lord, merit cum seniority. And also, my lord, in the notice, even if they have in the resolution, they have said that there will be a total marks of 50, out of the 30 will be the pass mark. In the notice, if your lordship will kindly see the notice at page number 49, the notice does not reveal anything, that there will be an interview, pass mark will be 30.
Notice it should not be mentioned.
Well,
Yes, why haven't you filed your affidavit?
I received the instructions, my lord, and records also. My lord,
When did you fix this 30 marks out of 50?
my lord, it was by that resolution, page 47.
Page 47.
Yes, my lord. This was 19/1/24.
So on the date of selection, or this notification, so this is prior to,
On the same date, my lord.
Huh?
On the same date of the advertisement,
same date of the
page 49,
page 49.
9/1/24, on the same day itself, my lord, 9/1/24, the meeting was held wherein it was resolved that there will be 50 marks, out of that 50 marks, there will be,
Before the election, before the selection.
yes,
Selection was held on
Before-
when?
election was 22/1.
22.
Then
It was before. Lord, if your lordship kindly considers Maheta judgment, your lordship seen para 84, 85, 87, 90, and 92. Lord, Honorable Apex Court has dealt with this.
Which one?
Lord, that R.D. Maheta versus High Court of Gujarat, 2024 SEC Online, SC 972. So 30 is not, in my submission, my lord, 30 is not excessive. And records,
30, if we say 30 is to be excessive, then all high court matters has to go.
because lordship will also appreciate one
Isn't
thing.
it?
Yes. My lord, minimum merit doesn't mean that you get 5 or 10. That means the merit element has not been wiped out.
Yes, where is the judgment?
2022 SCC Online SC 972.
2022.
Yes, my lord. Sorry, my lord. 2024. I'm sorry.
Name?
This is name
But I have a
Ravi
copy-
Kumar,
Copy of the judgment. I have a copy.
Ravi Kumar Dhansuklal Maheta and another versus High Court of Gujarat and others.
This one I remember.
Yes, lordships referred in previous 1 or 2 judgments.
Then where?
Para 84, 85. It says it's the prerogative of the appointing authority to select the mechanism and fix the minimum merit. If the promotion is given on the basis of merit, then there will be violation of seniority cum merit. After ascertaining minimum merit.
No,
if the-
it's okay. Let us first look into what he said.
Yes, madam.
He says that 60% is too high. Why? Show me somewhere,
Kindly
something.
see the judgment Bhagwan Das Tiwari, man. I have placed one.
Yes.
At page number 20, para number 20.
Yes.
There is no basis in the instant case for the stand that for assessing merit, a minimum number of marks has been prescribed. The contention that minimum marks were 45 out of 60 means that an employee is to secure 75% of marks. Such a high percentage cannot be a measure for prescribing minimum marks to assess merit. It obviously would be a case of shifting the focus to merit comes seniority principle.
See, paragraph number 20 starts with what? There is no basis in the instant case
Yes,
for the stand
yes.
that for assessing the merit, a minimum number of
Yes.
marks has been
For
prescribed.
that, my lord will kindly see para number 16, because in that circular, there was no basis. Para number
So
16.
therefore,
Yes.
there was no circular, but
In
they,
our notice
prior
also-
to their selection, they have come up that we are going to take 60%. What is wrong?
In our notice also, it is missing, my lord.
Not necessary. In the notice it is there, but if it was done at the time of selection or after the selection, in many cases they do, for which I have set aside. Then it is a case of Article 14 or comes into Article 16 comes into the picture. But here in the case, you cannot merely say that 60% is bad. There has to be something. They have categorically come up at page 47. Kindly see. After threadbare discussion, the board has formulated the modalities to be followed while conducting the interview for the post of UD assistant and form the interview board consisting of 3 members for a year. The selection has been categorically laid down the criteria for evaluation of the candidate for the post of UD assistant by interview board. For a year are to be evaluated and are marks in the following yardsticks. Marks from ACR 10, marks on personality 10, marks on general aptitude 10, marks on minimum qualifications, minimum HS pass, higher qualification carries weightage in marks 10, reading and understanding the skill 10. The board also resolves that the qualifying marks for promotion to the post of UD will be 30 marks. The board also discussed and resolved holding of an interview of the following eligible candidates for filling up of 22 posts of so and so from Iman. So what is wrong? These I think the court cannot interfere. Will have a far-reaching consequences if we interfere. Is there anywhere any judgment as to how you fix this minimum eligibility?
That is
criteria?
not there. That is very different.
Somewhere it is given, is not a case where minimum qualifiers are prescribed for assessment of performance and merit in those who secure the minimum. Prescribed minimum. Now, Mr. Kindly come to page 48.
Page 48, yes. Yes, madam.
How do you justify 4? Serial number 4.
Yes. Qualification, minimum HS pass, higher qualification carries weightage in marks.
How? That is not requirement for minimum. That is not the minimum qualification. How do you bring this aspect? All other things are okay. This is for minimum. Marks on service, marks on personality, very well. Marks on general aptitude, very well. But how do you give higher marks for higher qualification? Then isn't it touching on the merit? Reading and understanding, okay. All these are very well. It will come as regards the minimum. But how do you take care of number 4?
The qualification, in ascertaining, my lord, minimum,
No, minimum
Thing.
too. You see, the word is minimum.
my lord,
Understood?
Yes.
So all 1, 2, 3, 5, very well.
we are using this word minimum, but the whole idea is.
No,
to-
Are you submitting that?
No, no, no.
No, are you
I will not
submitting the
take-
whole idea is
No,
don't
no.
go by that. We
No,
are not
I'm
on
going,
that.
no, I'm going by the Supreme Court, what the Supreme Court. has-
Whatever may be, but how do you take care of giving more marks if somebody is more qualified? Then the minimum aspect is gone. Therefore, I'm saying 1, 2, 3, and 5 is perfectly fine. I'm not on that. These are required. Of having the minimum benchmark, you require that. But you don't require number 4. You say that the qualification minimum HS pass. Okay. But if a person is higher qualified, then you give him more marks, then it does not touches on the minimum aspect.
No, if, subject to my lord, what your lordship approves. If we are ascertaining a person's merit,
You're not,
With-
you're not.
no, I'm just, let me complete.
No. The word used is,
I'm.
No,
I'm
no,
considering
no,
the
you see-
minimum
you
word,
see,
my lord.
first it is the minimum number of marks have been prescribed. You see, minimum marks to assess merit cannot measure the, you see, what is the word? Minimum qualifying marks are prescribed for assessment of performance. That is the basis. The word term
Yes.
is minimum qualifying marks are prescribed for assessment of performance. Why do you require that? That when he is in grade LDA you want to make him an UGA. So obviously, then in that case, what is required to be done is you have to have, he should have a particular benchmark.
Yes.
Without that particular benchmark, he cannot be granted a promotion because it will then spoil what is going to happen there in the upper grade. Because just for example, a person who does not know how to read, he has been an LDA, he has become an LDA from down below who has just the class 10 pass or 11 pass. He is a ground, he goes from there and becomes an LDA, and from there he becomes what you call, goes to the year. Then in that regard, he may not, this person very much may not be in a position to read. He may not be able to do a particular work which is meant for a higher service. Understood? So therefore you require a minimum marks. Now, how do you give more marks if he is overqualified? There it is on
Not a case of overqualification.
no,
It's
not
a case
overqualified.
where
Higher qualification carries weightage in marks.
It's a higher qualification.
So therefore,
So-
when it is a higher qualification, meaning thereby, are you not going on the question of giving more qualification, more marks? Just for example, a person who is an BA or an MSc may get a higher mark than who is just a HS pass.
Yes,
But this HS pass can very well be good in his ACR, one.
yes,
An HS pass may be good in his personality.
yes,
An HS pass may be very good in his general aptitude.
yes.
And an HS pass may be very good in reading and understanding the skills. He
Yes.
may,
Yes,
he may.
Yes.
But he may not have that. How do you bring this aspect, number
You know,
4?
in my respectful submission,
Because show me how is it possible that you have not filed your affidavit?
yes, that's
So
true.
therefore, we take it you have not filed an
No,
affidavit.
I received the instructions.
We will go on this and hold it to be
No,
back.
I'll file the affidavit, my lord. I have
No, not
received the
necessary.
instructions recently.
No,
I-
no,
I-
this was
I can-
given on 16/12,
Yes, why not?
2024. We are in
Nothing is pending.
2025.
I'll not take that
Notice
excuse.
was issued on 16/4/2024.
14/6/24, my lord.
14/6.
Yes.
So-
No, I'll not take that excuse, but I'll just try to
How do
answer.
you explain number 4? I'm 1, 2, 3 is okay.
My lord,
It is subjective for this particular person concerned. But don't you think that it is an objective
no,
satisfaction
in my.
on number
submission-
4?
In my submission, serial number 4, wherein the selection committee decided the higher qualification will carry more mark.
Why?
No, that will not go into assessment of merit, in my humble submission.
Yes.
For-
That is, may not go on the assessment of merit, but goes on the question of minimum. You see, seniority come merit, you are permitted to have a minimum benchmark. That is the basic. CBI or all these judgments have
Yes.
categorically stated one thing,
Yes,
that you need to have a minimum benchmark. The moment you are having one consideration as a minimum benchmark, which has the effect of taking into account the relative merits or a person's qualification. Can we have that?
no,
Like
in
in
my
our High
humble,
Court, I'm telling you, in our High Court, we are having as one notification is 1:5. But you put this 60 marks. You say it is 50 marks or 30 marks.
30 marks.
30 marks. But you say 18, meaning that it is 60 marks. Okay, you have to get 18 out of 30 as per the High Court notification.
Which one will?
There is the only one notification.
Oh, yes, yes,
1:5.
yes, 1:5, yes,
There is merit cum seniority there also.
yes.
In the merit cum seniority also, you are putting it that he has to get in the ACR. If you have put this, what do you call the 30
No,
marks out of
that,
50.
that is
No,
in
I'm
my
saying
humble
that.
submission, that is different. Why I'm saying so? Because, Lord, fortunately on that day I was there inside the courtroom, an argument was placed before your lordships that if anybody get 18 marks, he will only be carried to the zone of consideration. that proposition in my humble submission wrong. It's since history, the proposition of forming the zone of consideration is seniority. Irrespective of fact who has got marks in ACR or not, what marks he will secure in ACR or not. It has to be based on seniority. The moment we assess the ACR marks to form the zone of consideration, we are considering his merit, putting the cart before the horse. That is, in my I'm not at all in agreement with that submission, my lord, or that proposition of law. Seniority, my lord, zone of consideration has to be based on seniority.
But
Rest,
if it is, the zone of consideration is to be based on seniority.
yes,
But that seniority has to be mentioned in the rules.
my lord,
How do you do it?
I haven't seen I have not applied my mind,
You will
with
find
regard
it
to the rules.
in another case, you will fail. There's no rules.
No, so that's why, but
Guwahati High Court doesn't have a rules. We have a notification.
yes,
This notification says that one post, 1:5,
yes,
two posts, 9,
yes,
three posts, 8.
yes,
And when it is 100 posts, it is 150, 171 or something.
fine.
This is how they have it. But unlike in all service laws, wherein it say that it has been taken from the gradation list on the basis of seniority, that aspect is not there. So
Yes,
the basic fundamental on which it is being premised out there is like this.
yes,
That all these persons concerned, they will be first taken a person to be eligible, to be brought within the zone of, not only the zone of consideration, I'm not saying zone of consideration, to be eligible for consideration.
my lord, yes, I
Okay,
understand.
You see the language used.
Yes,
Eligible for consideration is having 18 marks out of 13 the ACR. Okay.
eligible for consideration for promotion
No,
or selection, whatever, my
no,
lord,
no, no.
whatever term is used
no,
there.
no.
All right,
First, being eligible. He has to get 18 out of 30 for being eligible. Once he gets 18 out of 30, then the marks will be held out of 100. Okay.
yes,
Then there will be examination held. And then they are going to do it as to 1:5. But the problem arises there is that there is a missing link out there. How do you do it even after assessing those people? Just for example, in a particular cadre where you are bringing somebody from a particular to one post, where you are having some people getting 18 out of 30 in maybe around 70 or 30 or 40 people. They all have to be taken into consideration. This is how it is being done. Like you see the stenographer's thing also.
yes,
You did see the selections, how they have done out there in the grade 2 and grade 3 out there. They have brought in all those people who have got these particular marks. And then they have held that selection, then they have to get 40 or 50 marks out there, or whatever, maybe 30 marks, then they get it. Then there is again an interview, it is being held. Now, my question here is, no doubt, why I'm referring to that notification is, that is absolutely based on an ACR. You are having the 18 out of 30. So, one can very well say that if a person is getting 60 out of 100, because 18 is out of 30 is 60.
yes,
So if a person is getting 60 out of 100 in the ACR, he meets the minimum benchmark. One can very well say, like here also, a person who knows how to read, has the basic thing, he can very well have it. But a person who has a higher qualification to have the minimum requirement is the problem which I am facing.
my lord, the presumption is that with regard to higher qualification, it is, my lord, it is always presumed that a person with a higher qualification will have more qualities.
No, you cannot. Then you are having, you cannot take that. then why you, that may be a question out there in the merit, in the interview. You may have that, but not here for having the minimum benchmark. Then the basic idea behind the minimum benchmark goes. I'm in agreement with 1, 2, 3, and 5. Yes, this is because that is subjective. These are ACR is also subjective. Reading capability is also subjective. All these are subjective. But a person having higher marks, higher qualification is not subjective, it is objective.
The, the, can the qualification be a
For minimum,
parameter for
how
minimum?
do you have it for minimum? Because he is otherwise eligible because he
No,
is HS.
no, minimum is for the overall.
Understood. So
Minimum is for
therefore,
overall.
how do you bring in that consideration? For minimum.
No, I just, if I just explain, my lord, this word minimum is vis-a-vis 50. So this is one of the component
For that minimum.
for that minimum. So if it is not only on the basis of this, the minimum was ascertained. The
We are
selection-
concerned here with a very minute fraction.
I understand, my lord.
Here, the
a very
petitioner would
delicate-
have scraped in because the petitioner had got 29.33 out of 30.
Yes,
There's a major consideration out here. So this minute thing would have a difference out here from here to there. You even did not say it
if
because here is a case of 29.33.
I
have
have seen
understood he has got
26,
15 or
25, I
17 or
understood,
20
I
out
have
of
seen.
10.
It's very, very
Very
minimum
negligible.
margin.
And more particularly when two interviewers have given 34 and for 30, whereas one has given only 24. Isn't it?
And the breakdown of the marks is also not available.
34, no, I have got the breakdown of the
There.
marks I have.
I've seen it in the file. No?
Yes, yes, it is there.
I leave
The,
24, 34 and 30. So two persons have already given him 34 and 30. And one person has given him
basically,
20.
if I may not see the, the breakup of the marks, her marks reduced in, my lord, 3, 4, 6, personality, then, my lord, general aptitude, and, my lord, reading and understanding skill. The select, my lord, the member number 1,
Show me.
she has, I'll just, she has given 2 marks for reading and understanding skill, and other members has given 5 and 4 respectively. So it's,
Only the CGM has given badly.
look, apart from that, I'll just,
Here she's got fine.
yes,
Yes,
ACR, all the persons will not same marks because 4 very good, 1 good. The gradings were, all the 3 persons, my lord, they got same grading, so same marks were given to. Otherwise, my lord, I have seen the record. Otherwise, my lord, I don't find any infirmity in, my lord, considering,
Absolutely. I find that infirmity only on that.
my lord,
How
if-
do you put higher qualification?
if we go by the, my lord, Supreme Court judgment,
Ah.
the Honorable Apex Court has said,
Ah.
because we'll have to take care of that also.
Ah.
They have said that how the minimum merit is to be ascertained, it has been, it is the discretion of the selection
Oh,
committee.
yes, there's no quarrel. But can you say it to be higher qualification to be minimum merit? I'm on that. I hope I'm able to make you understand.
And
Can minimum merit, bracket of being minimum merit, be put into the scheme of as regards higher qualification be brought within the scheme? Because these two persons otherwise have got 9-9.
yes,
Both have got 9-9, whereas the petitioner has got 7 and 8, and I don't understand why. How?
qualification
How?
perhaps needs to
How?
be there.
No, I don't understand why. Because kindly see here. In this thing, you can go ahead.
Then
No. If a person is having a highest qualification, how can there be different marks by all in respect to the qualifications? Because this is an objective. It cannot be subjective. You see what the petitioner have got? 6, one has given 7, and one has given 8. How is it possible? All three giving different marks. That means you have not set up the benchmark.
means perhaps on the basis of qualification, they have given marks. And what is the
My
qualification?
petitioner is graduate, my lord, BA pass. These two persons are also BA pass. But the only thing is that, my lord, have some computer degree because they come from the typist cadre, my lord. That makes the difference. So
That is a
is
different
not a
thing.
form.
But how 3 persons have given different? That means you don't have a benchmark because this is objective. Other things are subjective. One person can very well say. But how do you say about benchmark on this?
Milord, I'll answer this, Milord. That whether qualification can be a factor for ascertaining minimum merit, Milord, I'll have to answer this, Milord.
That is one. And secondly, it cannot be subjective. Qualification cannot be subjective. Qualification has to be objective. Meaning, if somebody has a BA, you may give him 5 marks or 6 marks. Some additional degree, it will be given. But it seems your people out here, the screening committee did not find out how they are going to distribute these 10 marks. Get the point?
I'll do some more homework and I'll just try to answer this and I'll,
Because that has to be understood. Because here, because
your lordship's
I
contention-
would have understood if all have given 6 marks.
Yes, your lordship's contention is that since you have fixed an educational qualification, if they have fixed fulfilled the educational qualification.
Contention is his.
Yes, I'm sorry. Milord, the petition.
My query.
Milord, my apologies. That is the petitioner's contention. If there is a
He has
qualification.
not made it. I have made it.
That's the nicety, Milord. We are learning day to day. Milord, I'll come up with the
Because
answer.
this is something what, you see, in this case, something may go this way, but this aspect has to be brought in. Because in nowhere,
Clarification has to be there of this thing, that if you have fixed an educational qualification, can you give more
Different.
marks or different marks on the basis of someone getting higher qualification or not?
no, you may give. There are 2 questions. First, can minimum, for judging the minimum, you take into consideration the qualification.
Yes,
1. Secondly, because then what you're touching is, you're touching on the eligibility conditions which say that a person to become an LDA, from LDA to UDA, has to be an HS. It's a different thing. It's a different thing that all are, what you call, graduate.
yes.
It's a different thing. But are you not touching on that?
One could have been HS also.
So you're
What would have
touching,
been his mark? And
so you are touching on the eligible rules. which says that a person from being an LDA to UDA, he needs to be a HS. So there one. So can you have that, number one? And secondly, if you have that, if you are permissible, as it is an objective satisfaction, can you do so without fixing a benchmark on that? As to how you are going to give this mark. Because here it appears to be different for everybody. Likewise, for the the private respondents, both have got 9-9. But the three members have given, one has given 5, one has given 6, one has given 7.
6, 7, 8. The first gave 6, 7, 8, then 7, 8, 8. The last one gave 8, 8, 8.
How is it possible?
I'll come up with the answer. But so far as Lordship's second query is concerned, that whether there should have been a benchmark in this, you know, that will amount to going to fine tuning the entire process.
So that
Perhaps.
because you are fixing it,
Yes.
because there cannot be
Because that
difference.
will be because we have
Therefore-
only fixed 30 marks.
No,
And it will
therefore,
again,
therefore the question is,
first question I
no,
understand.
therefore the question is, because after all, having more qualification, as I'm saying, is an objective satisfaction. It is not a subjective satisfaction. Because here you know that this person has this much. And if it is an objective satisfaction, you have to objectively have the benchmark. Then only you can be satisfied.
It will be a benchmark upon benchmark.
No, this is not
The
a
moment we
benchmark.
say
No.
the HS,
Mr. Das,
I-
let us,
I'm
let us,
sorry,
let
Milord,
us take
perhaps
the,
I failed to.
no, let us
understand.
take the example of two aspects. You have done a lot of case on NSA. NSA. It is the subjective satisfaction of the particular officer who detains him on these other basis that he is likely to commit and so and so, so and so. So this is a subjective satisfaction. Now, whether he has committed that offense or not, it has to be on the basis of the offense. It is an objective satisfaction.
Correct.
Okay? So here, how do you say that he has committed the offense? When there is always a benchmark given out there for the offense. So therefore,
I
my
got your
question
lordship's
is, when
point.
you are having it as an objective satisfaction, where is
It's
the
fine.
benchmark?
I understand.
Mr. Das is not argued.
Well, I'll argue well, next day on this.
But I'll come up with the answer, my lord. Lordship will give me some time. And in the meantime, I'll try to file this.
Let me give the credit to Mr. S. Das of what has come up from me as his submission and record it in the order.
No, this
so
is,
that for
no,
you
this
to
is
come-
beneficial for me also, my lord. As because of your lordship's query, I'll do some deliberation and I'll also learn in the process, my lord. So it's very helpful
No,
for us.
other things are
And this is
okay.
absolutely fine tuning of this principle, my lord. Seniority cum merit. My lord, otherwise seniority cum merit, my lord, lot many judgments are there. But to what extent and when
No,
regarding the
If you
criteria,
are having an ACR, not necessary.
I understand.
Because there also, if you see,
It's
in ACR also, it is also done objectively.
yes,
Because you also have, I think that is all settled out there.
yes.
I'm telling about the High Court. If you have an outstanding, then he gets 6.
Yes, there is a notification. Yes.
VB, very good, it's 5. Good is 4. So this is also an objective satisfaction
Yes,
on the basis of the parameters.
attributes and their.
So you have to therefore understand as to how, because I would not have much gone into it, but this is a question of very touch and go.
0.7,
0.77.
77 marks,
0.7.
0.77 marks.
And there is also no mention. It is in most of the selection proceedings, it is mentioned that it will be taken as the average of the 3. Where is it?
It's out of 50.
No, no,
they have taken, yes,
no, I'm saying it will be taken as an average of 3. Where is it?
3 members.
Where is it?
It's there, my lord.
It's not there. Page 47, read it. Let me come back. You read it in the meantime. The S. Das Sutherland counsel appearing on behalf of the petitioner. And Mr. H. K. Das Sutherland counsel appearing on behalf of the. You appearing for? Appears for the respondent number 76. Yeah, appears on behalf of the Department of the Government. The petitioner herein have assailed the promotion given to the private respondents by the Chief Judicial Magistrate Hosai by the order dated 24/1 by the orders dated 24/1/2024 enclosed as annexure 13 colli to the instant writ petition. Full stop. Mr. Estes, the learned counsel appearing on behalf of the petitioner, has drawn the attention of this court that the petitioner herein is senior to the private respondents in the cadre of the lower division assistants. Full stop. The learned counsel submitted that an advertisement was issued on 14/10/2020. Isn't that? 14/10/2020,
Yes.
10/2020, for the purpose of which is the advertisement?
Advertisement, my lord, is it page number 47,
47 is the advertisement.
resolution, my lord. On that basis, my lord, all letter was published at page number 49.
Admitted that a resolution was taken by the selection board. Advertisement to Kati Diba. As that the learned counsel for the petitioner submits that a resolution was adopted by the selection board for filling up of 2 vacant posts of UD assistants by promotion. In the said resolution, out of 50 marks, 30 marks was held to be the qualifying marks for promotion to the vacant posts. Full stop. Referring to the criteria by which the 50 marks were to be the 50 marks was distributed. The learned counsel for the petitioner submitted that the criterion at serial number 4 could not have been taken into consideration for adjudging the minimum requirement. minimum qualifying marks as the same would affect the very eligibility criteria for promotion to the post of UD assistant. He submitted that the educational qualification required for the post of UD assistant is HS passed. Any higher marks being given on the basis thereof would amount to tinkering with the said educational qualification. He further submitted that for the purpose of adjudging the minimum qualification required, qualifying marks, comma, educational qualification which is already been stipulated in the rules could not have been taken into consideration. The learned counsel further during the course of the proceedings, Mr. H.K. Das has placed before this court the records as to how the selection was carried out. First, from the said records, it is seen that although the minimum qualifying marks was fixed at 30, but the petitioner herein had missed out the said minimum qualifying mark by a fraction of a mark. That is 0.67. As the petitioner had got 29.33. The learned counsel further submitted that the criterion at serial number 4 being qualification and higher qualification carries weightage in marks. Can only be objectively adjudged and cannot be subjectively adjudged. Referring to the marking which have been given by the 3 members of the board, of the selection board, Mr. S. Das, the learned counsel, submitted that in respect to the criterion number 4, one member had given the petitioner 6 marks. The second member had given 7 marks. And the third member had given 8 marks. he further submitted that even in the minutes of the minutes of the selection board held on 19/1/2024, there is no whisper as to how the criterion for how marks in respect to criterion 4 is to be determined. First, the learned counsel for the petitioner further submitted that even a perusal of those minutes also would not show that they show that the average of the three average marks secured, granted, given by the three members would be taken into consideration.
Average is there, Melo. Average marks obtained by the three members was calculated in the, that's
Would be given, where is it? In 19/1.
in the resolution.
That is his submission. You may not know it's different thing. First, on the specific queries, so on the basis of the said submissions, so made by the learned counsels, learned counsel appearing on behalf of the petitioner, this court had also inquired with Mr. H.K. Das, the learned standing counsel of the Guwahati High Court. He submits that he would like to obtain instructions in that regard. This court have also taken note of that in spite of the notice was issued on 14/6/2024. And we are and as this 24, until date, no affidavit has been filed by either of the respondents. Taking into account the above, this court fixes this matter on 5th of June 2025. The respondents herein are granted liberty to bring on record their stand by filing the affidavit on or before 28/5/2025. The petitioner, if so advised, would be at liberty to file their reply on or before 4th of June 2025. List according.
Highly obliged.
Much okay.
Item 5.
Petitioner was appointed as a grade 3 stenographer in the establishment of District and Session Judge Nagaon. Thereafter, she received the salary as per the advertisement. issued.
That I know. You were just, this matter is just being postponed from one day to other just to dismiss it. When should I dismiss it?
Lordship, the finance department has filed an affidavit and therein they are relying upon an office memorandum, Lordship. That office memorandum, Lordship will find that
You were appointed after the 2007.
between, yes, I was appointed on 21/9/2016, Lordship. And I joined on 22/9/2000. After that, the ROP 2017 came, Lordship. And the finance department basically in their affidavit has relied upon one office memorandum that is at page 19, Lordship.
Wait,
page 90.
90.
Yes, Lordship. Lordship, while relying upon this office memorandum, they say that my initial pay has to be fixed. Page 79, Lordship, may kindly bear with once, Lordship. Page 79, that is their statement, Lordship. The paragraph.
Hmm.
The first line may be skipped, the next paragraph. As per OM number so and so dated 28/7/2010, the government in finance PRU department laid down 15 grade pay corresponding to 15 numbers of revised, pre-revised pay scale as direct entry pay scales. The pay structure will not only be applicable at the time of entry in service of those government servants as on 4/2/2010. The above mentioned pay scales were only meant for directly recruited posts. In the OM dated so and so, the grade pay of 2,900 pay scale of which is the pre-revised pay scale of which is 3,850 to 7,350 was not included, as this pay scale was meant for promotional posts. Lordship, they have given a calculation, Lordship, thereafter. As per this calculation, they say that the initial pay that of 10,700 that was 70 that was given to me was wrong, and in the subsequent paragraph they say that it ought to have been 7,170 instead of 10,070, Lordship. Now, this office memorandum, which is at page 90, Lordship, is, I have filed a reply and stated that this is not applicable in my case, Lordship, because the scale, the pre-revised scale is not here in Lordship, and there is another office memorandum of 2011, Lordship, wherein that pay scale was included.
Where?
That, Lordship, in my reply,
115.
yes, Lordship. 116, that 2,400 was revised to 2,900, that is their, Lordship. And at page 114, the initial pay of 3,850 was revised to 7,170, Lordship. So that was the initial fixation that was to be made, Lordship, as per fitment table 10, Lordship. This is under the ROP rules 2010. 114, Lordship. They say that, Lordship, the initial pay has to be 5,200, Lordship. But in terms of this fitment table at page 114, Lordship, the corresponding pay of that revision is, Lordship, 7,170, Lordship. So it cannot be 5,200, Lordship. What has happened? This calculation there was a query made by the district and session judge Nogam before the finance department. And in the affidavit by the finance department, they have stated that they did not receive it on time. But however, they said that the query which the district and session judge Nagaon was to be, basically the fixation has to be made as per this ROP rules 2010 lawsuit, and that lawsuit will find page 101 lawsuit. Page 122 lawsuit.
As per the finance department, you have to get 14,000 to payment of PP to 14,000 to 70,000 plus GP 7,400.
Yes, Lordship.
You were recruited after 1/1/2016.
Yes, Lordship.
That's the reason.
Lordship may kindly turn to page
But you
120.
were being given what?
I was given that the initial pay, they counted it as 5,200 and plus that grade pay lordship of 2,900.
You can't get it after as per 5,200. You were appointed subsequently.
Lordship, as per.
Maybe you were appointed then, but at that point of time, the earlier pay was given
Lordship.
of 5,200. That was given. But with effect from 1/1/2016, the seventh, this 2017 pay commission has come in.
Yes, Lordship.
Then
Yes, that's what I'm trying to satisfy, Lordship. That is at page 122. Lordship may kindly peruse page 122 once, Lordship.
1.
22. The second paragraph, Lordship. However, regarding initial fixation of salary of stenographer grade 3 who joined in the year 2016 before publication of ROP 2017, action may be taken as per provision 5 of notification number so and so dated 17/3/2017. Now that notification provision 5 lordship is at page. This is by the finance department only, lordship.
Where's the 2017 notification?
Page 123, lordship, that extract, lordship, provision 5. Save as otherwise provided in these rules, a government servant, government employee who is in service on 31st March 2016 or who may have been appointed on or after 1st April 2016 shall draw pay in the revised pay structure, pay band with grade pay applicable to the post service which he has been holding or to which he may have been appointed, as the case may be. So his appointment.
So you mean to say that by virtue of this,
Okay. By virtue of this, that pay scale I ought to have got lordship, and this matter,
So you come within the exceptions
yes, lordship, yes. And
in
all
view of the proviso to that rule of two thousand
17,
seventeen.
yes, lord.
Where is that rules?
That rules, I have got a soft copy, but then I have got the soft copy lordship, but that's the whole one lordship.
Only that thing I require, na?
This one is the thing lordship, that provision 5 lordship.
Where is the finance?
And subsequently, Lordship, one Azizul Haq Chaudhary, he was appointed along with the petitioner in that establishment also, Lordship. He was subsequently transferred to Kamrup under the establishment of the district and session judge Kamrup, Lordship. And he is facing a similar problem, Lordship, and he made queries. Herein also in district and under the establishment of the district and session judge Kamrup, similar problem arose, Lordship, and therein some communications were made, and the judicial department clarified that, Lordship.
So for him, it has been done.
For him, for the period of him,
Lordship, Mr. Arbogazari is arguing this matter. He's not legging court 10, your lordship, the Pathway matter.
for the period which he has served under this establishment of district and session judge Kamrup, Lordship, that benefit has been given to him. Lordship. And the finance department has already forwarded their views to the judicial department on 12th April 2024, Lordship. That Lordship will find at page 102, Lordship. On 12th April 2024. Even after making these calculations, they had forwarded it to the judicial department, Lordship. Page 102. And judicial department, Lordship, that Azizul Haq Chaudhary had preferred an RTI to know as to what, how the calculations were made by the judicial department. Those calculations, Lordship will find that the note sheets pertaining to that file were given to that Azizul Haq Chaudhary, Lordship, and the calculations were found therein, Lordship.
This has been done in 2020.
Yes, Lordship. Starts at page 126 onwards, Lordship.
What is your name? Hatri Das.
Yes, Lord.
So he got, on the basis of this, he got the benefit. On the basis of that proviso.
Yes, Lordship. Not only he, Lordship, all the other requests in who.
So if this is being done, then there is no question of recovery.
No, yes, Lordship. No recovery can be made, and the fixation has to be made in terms of this, Lordship. The current fixation. As well as the other pays are also not.
Yes. What is your stand? You have filed an affidavit?
Yes.
What is your stand?
Look,
Have you
it
seen his
was-
reply?
Yes, my lord. That,
What is it?
that be so if somebody else has been passed on with the benefit.
No, somebody, the department has given the benefit, but whether it is permissible as per the fifth proviso to the notification dated 17/3/2017 is the question.
Yes, my lord.
And he has enclosed it at page
122, my lord.
123. Well, we have it after some time when he comes. Proviso. Proviso. On 17/3/2017.
Item six,
May I please offer? My lord, I am inquiring on behalf of Mr. R. Islam, who is my lord out of station. My lord, R. Islam, my lord, who is the counsel for petitioner, my lord, he is out of station, my lord. My lord, let the matter may be action for 30 minutes.
Affidavit?
But I have filed the affidavit.
Affidavit, my lord, reached today, my lord. They have
You have filed today.
today. Yes.
No, I'm.
So what is your stand?
My lord, I am not in this case, my lord. So let the matter action today, fixed for another.
What is your stand, Mr. Das?
This, our stand is that their contention that she was not, EWS, she did not apply as EWS, my lord. We say that that was an inadvertent mistake in page 37. Their contention is that her roll number, that is PS 0194, that came under the column unreserved. So did not apply as EWS. Our contention is that this notification, it was a clerical error. She applied as EWS. We have, my lord, submitted her certificate, my lord, application also, wherein she has written that she applied as EWS. So her selection at annexure 39, annexure 5, page 39, as EWS woman is not erroneous. Their contention is that in page 37, you have mentioned her as unreserved. How can you select her as EWS? That is their contention. We said
You have
that,
filed your affidavit, no?
yes, my lord.
Okay, you file your affidavit. You want to file reply?
My lord, yes.
Has been submitted by Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, that the affidavit has been filed today. Full stop. The learned counsel appearing on behalf of the petitioner seeks for some accommodation for filing a reply. Full stop. List this matter again on 12th of June 2025, comma, reply if any be filed on or before 5th of June 2025, full stop. Mr. H.K. Das shall produce the records on that.
Look, affidavit filed day before yesterday, my lord.
Are they everywhere?
item seven,
Das also submits affidavit file, you may file it.
Much obliged.
Have the instructions.
Judicial Department?
Yes, Lordship, we have instruction, Lordship, that everything has been communicated to the finance department, Lordship. This is there.
Lordship, this is a March communication, this is not,
Yes.
Lordship, we have that proposal which my learned friend had submitted, Lordship, there the financial implications, the amount that has to be paid, that part was missing as per the communication, Lordship. So we had returned the file back to the judicial department. And whether they have, with the financial, sent a fresh proposal, Lordship, that we have not received till date, Lordship. My learned friend, the instruction which my
Okay,
learned,
Lordship, then I'll take the
that
updated
is of March,
instruction.
Lordship.
Yes.
March is okay, so therefore it was, if it was sent in the month of March. Listing register as official has been received from the Judicial Department, file number so and so. Been returned on 24, requesting for funding. When did this person retire?
He retired on 20th of June, 2022.
Why is it taking such a long
No,
time?
Lordship, after retirement, he was given the special accommodation. It is after retirement, he has been given that post, Lordship. Re-employment.
No, after that.
Yes.
Are you still functioning?
No. I was appointed for
When did you cease? When did you cease to complete your term as an OSD?
OSD 20/06/2022.
That is what I'm saying.
20.
Why did it taking 3 years for that?
Yes, Lordship. Lordship, as soon as the financial year, we just need to give our approval, Lordship. Now in the proposal, the set proposal.
You are the main problem.
Lordship.
Problem is being created by the finance only. Everybody doesn't have any problem.
Lordship, the amount that needs to be sanctioning, Lordship, that
Why the judicial department doesn't know how the finance department deals with the matter? Madam,
Lordship,
why haven't you mentioned the financial implication?
Lordship, may I read one thing, Lordship?
And
Lordship, as
has the High Court also not mentioned what would be the financial implication?
that is already clear, page 17. I could have
Page?
17 of my repetition.
Yes, it is given monthly pay and allowances, grand total 1,05,000. So and so, therefore the monthly salary of so and so OSD will be so and so minus a month 56,800.
818.
Yearly financial implication would be 6,81,800. At present, sufficient fund is available under the head of account so and so. In the current financial, in view of the above, I will request you to kindly take up the matter with in the state government to accord necessary sanction for engagement of so and so on re-employment as so and so. This was given even prior to his appointment. Then, what is wrong with this? He has been discontinued from 26/2022. Then Joint Secretary said regarding engagement, I'm directed to inform you was moved to the EC for approval. EC has advised to fix the remuneration of so and so as OSD in the High Court as per government notification copy enclosed. So and so. Then it has been 2022, it has been written. Engagement of so and so, your letter dated so and so, 30,000, so and so, 1,05,000. As per PPO, basics return is this much, 52,000 and so, this was given in the year 2022. Register general against payment for remuneration. Then again, it has been written by Joint Register Administration to LR. What is wrong? You say that it has to be done in that manner. It has been accordingly done in that manner. Then what happened?
Lordship, here,
Why you are not aware?
Lordship, here, these letters are interdepartment, that has been written to the LR Judicial Department, Lordship. The proposal that was forwarded to the Finance Department, Lordship, on the basis, Lordship, that it was online, Lordship, which I have the proposal also, Lordship. It was served to me on my WhatsApp, Lordship. They had sent that proposal in the year 25, Lordship. That proposal was sent in the 25. These letters and communications are 22, Lordship. That financial year is already over. And in that letter
You are
also,
concerned with that financial year.
for this financial year, Lordship, only, Lordship, here, if the fresh proposal along with the financial implication is forwarded, we'll give our concurrence, Lordship. The amount is not that high.
Then
It
why is it not happening?
Lordship, only when if in the.
No, why is it because of you, both of you, this is happening? Absolutely, both of you, either the department doesn't know how to write a letter to the finance, or the finance doesn't want to recognize that the department has any knowledge how they can write a letter. Either of it. Which one? As per you, the judicial department doesn't know how to write a letter.
I,
Which one is it? Or for you that you don't know how to write a letter to the
we
finance?
have just raised certain.
Either of it. It cannot be both. Which one?
Lordship,
This can't go like this.
No,
This
Lordship.
person was discontinued in 2022.
Lordship.
Then, and you have given your concurrence to that effect that go ahead. But you fix it as per this. This is what has been written by this at the Annexure 5 to the writ petition on 7th of June 2022. Has been advised to fix the remuneration in respect of so-and-so as OSD in so-and-so. You are hereby to submit the needful as advised by the Finance EC3 department. What is wrong? That means the if Finance EC3 department is no.
Yes, Lordship.
Then this is not here from 2022.
Yes,
Then
Lordship, here, since there is an expiration of the financial year, Lordship, of first proposal, that is what was sent, Lordship, on the basis of which I was asked to obtain instruction regarding the proposal. Now, in that.
no,
the
I never asked for. You submitted. On
the-
the last occasion, Mr. A. Solier, the learned standing counsel appearing for the finance department, submitted that the proposal is under active consideration of the finance department and finance has got 2 weeks for the purpose of processing.
Yes, Lordship.
This is what has been submitted.
Yes, Lordship.
Taking into account the finance will make an endeavor so that the amount to which the petitioner is entitled can be released at the earliest.
Yes, Lordship.
This is it. Now you have returned it thereafter.
Lordship, raising certain queries, if those queries have been met, Lordship, then we can give it finality and like give a concurrence, Lordship. We, as a Lordship, we have a duty to at least.
Who is going to pay the interest? Finance,
No, Lordship.
finance, you approve the interest also.
Lordship,
In your proposal, you give the interest 18%.
Lordship, here, in my humble submission, Lordship, once.
No, there's nothing out there. This is a person who is retired in 2022.
Lordship, I just want to read 2 lines, Lordship.
Which one?
The instruction that we received, Lordship. Lordship, as per the judicial department, Lordship, that the department's letter dated 7/7/22 from the registry of Guwahati High Court on 27/7/22. This department had forwarded the said information to Finance EC3 department for their concurrence on the proposal. The Finance EC3 department had requested this department to resubmit the file in e-file with a copy of PPO in respect of Sri so-and-so, retired assistant register, Guwahati High Court, and accordingly the file was again resubmitted in e-file and forwarded to Finance EC3 department for their concurrence on the proposal. The Finance EC3 department had their endorsement had requested this department to clarify whether approval of Finance department was obtained before engagement of so-and-so as OSD. Then this department had again requested the joint register admin 2 Guwahati High Court by letter number so-and-so dated 24/4/2023 to clarify the above observation of the Finance department. But when no clarification has been received, then a reminder was sent to the registry of GSC on 26/2/2025 after receipt of letter from the senior government advocate Assam by number so-and-so. And thereafter, the registry of Honorable Court by their letter number so-and-so dated 10th March 2025 had furnished the necessary information as sought for. And now this department has forwarded the information to Finance department for getting concurrence in regard to re-employment of so-and-so, Lordship. So what is the next step, Lordship? This is the letter of 19/3/2025, Lordship. So what next is happened, Lordship? In that point, I have to take instruction.
Finally come to this communication at page 22. of the writ petition. What does it say? Huh?
Yes, Lordship.
And then your communication at page, then the next at page 24, what does it say?
Yes, Lordship.
So why you are blaming the High Court and saying that they have only given only on 10/3/2025 when this communication of 27/7/2022 is already on record? Have you filed your affidavit?
No, Lordship. We
File
have-
your affidavit,
Lordship.
both of you. File your affidavit as to why not, and the persons concerned of your department and your,
Lordship.
their, from their salaries, the interest will be paid. The respective LR from there and from your, whoever is the commission. Their salary, because the government cannot pay for that interest from the government coffers, the government will pay, but it will be taken out from the salary of these officials. From the Commissioner and Secretary Finance Department and from the LR. How can this thing happen? Heard Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the petitioner. Mr. A. Soliha appears on behalf of the Finance Department, Government of Assam. Mr. M. K. Bhattacharjee,
M. Bhattacharjee.
M. Bhattacharjee, Ms. M. Bhattacharjee appears on behalf of the Judicial Department of the Government of Assam. And Ms. S. Sharma, the learned standing counsel of the Guwahati High Court. The petitioner herein who was working as an assistant registrar, Guwahati High Court, was re-engaged as an OSD with effect from 21/6/2021 to 26/2022. However, as the petitioner have not been paid his due salary, his remuneration, the petitioner has approached this court by filing the instant writ petition. It is relevant to take note of that after the petitioner's services as a petitioner's engagement as an OSD was stopped with effect from 26/2022. Almost 3 years have passed by, but the respondent authorities have not paid the remuneration. At this stage, this court finds it relevant to take note of that on 28/9/2021, the Registrar General of the Guwahati High Court had written to the LR cum Secretary to the Government of Assam Judicial Department informing about the re-employment of the petitioner as an officer on special duty and what amount the petitioner would be entitled to as well as the financial implication. It was also mentioned that the concerned head of account for the financial year 2021-22 also had sufficient funds for the purpose of making payment to the petitioner. Was- In spite of the said communication, neither the judicial department nor the finance department of the government of Assam took any stand, for which the petitioner services were disengaged with effect from 26/2022. It is very pertinent to take note of that on 7th of July 2022, the Joint Secretary to the Government of Assam Judicial Department had written a letter to the Register Establishment of the Guwahati High Court informing that the proposal was moved to the Finance EC, that's Roman 3 Department for approval. And the Finance EC, bracket Roman 3 Department, had advised to fix the remuneration in respect of the petitioner as OSD in the High Court as per the government OM wide number FEB.154/03/1 dated 7/4/2004. The register establishment was also requested to do the needful as advised by the Finance EC Department. Subsequent thereto, on 27/7/2022, the Joint Register Administration have written a letter to the Joint Register Secretary to the Government of Assam, stating inter alia that after applying the notification of the finance department, after applying the mandate, after applying the OM number FEB.154/03/1 dated 7/4/2004, the petitioner's salary after deduction per month would be 52,688, and the financial implication was also mentioned. Was 52,688, and it was also mentioned that the said funds were duly available in the head of account for the financial year 2022-23. Further to that, it was also mentioned that on account of not receiving the concurrence from the government, for engagement of the petitioner, it was inconvenient on the part of the registry to pay the monthly remuneration to the petitioner. The record further reveals that similar communications were continued were written from the Guwahati High Court to the LR and Secretary to the Government of Assam from time to time. That matter was listed before the court. On 23/2025, the senior government advocate, Mr. Deenat, apprised this court that the judicial department had forwarded to the finance department for getting post facto concurrence in respect to the re-employment of the petitioner. And in that regard had placed an instruction which was kept on record and marked with the letter X. Full stop. এই এগুলো এক্স ওয়াই জেড করা হয় এগুলো করতে থাকেন বুঝলি হ্যাঁ এক্স ওয়াই জেড করার বিষয়ে একটু what is wrong with this thing actually এখানে লিখিত না লাগে না when I know particularly when you pick up the matter. Taking into account that the finance counsel appearing on behalf of the finance department had also submitted before this court on 23/2025 that he would request the finance department to take appropriate steps. This court did not further go into it and fixed 27/3/2025 for the purpose of providing an update. On 27/3/2025, Mr. A. Solia, the standing counsel of the finance department, submitted that the proposal submitted is under the active consideration of the finance department and sought for 2 weeks. Considering the above, this court fixed the matter on 1/5/2025 with an observation that the finance department shall make all endeavors so that the amount to which the petitioner is entitled to can be released at the earliest. Today, when the matter is being taken up, Mr. A. Solia has brought to the attention of this court that the file had been returned back to the judicial department on 29/4/2025. Seeking various informations. The information so sought for were, number one, financial implications of the proposal. Number two, to furnish a copy of the rules, bracket, appointment, conditions of service and conduct, bracket close, rules 1967. And number three, to clarify on what principle the remuneration and other T&C of the re-engaged retired employees were fixed. The said communication which was the said instructions on the basis of which Mr. A. Solia had submitted before this court was placed before this court, which is kept on record and marked with the letter Y. In the foregoing paragraphs of the instant order, this court have duly given the details as to how the proposal was moved. This court finds no justification on the part of the finance department to return the file for furnishing a copy of the rules, as well as to clarify on what principles the remuneration of the other TNC of the re-engaged and other TNC of the re-engaged retired employee was fixed. More so, in view of the communication dated 7/7/2022 issued by the Judicial Department of the Government of Assam, which was issued on advisement of the Finance Department. This court further finds it relevant to take note of that in respect to similar employees, the Finance Department have given concurrence earlier, as would be seen from Annexure 11 to the writ petition. Some other employee, no?
Pradal Kumar Sharma.
First. The act on the part of the Finance Department as well as the Judicial Department to throw the ball in each other's courts to justify and thereby deprive the petitioner of his legitimate dues. Appears to be in violation to Article 14 of the Constitution. More so when there is no justifiable ground to do so. First. This court further points out, finds it relevant to take note of that even after the communication dated 27/7/2022, the finance written to the Judicial Department of the Government of Assam, referred to herein above, the Finance Department being not able to comprehend the financial implication that's a very sorry figure on the ability of the people manning the Finance Department. As well as understanding and manning the Finance Department. First, this court further takes note of that even after a passage of more than a year, even after a passage of more than 6 months, no affidavits have been filed by both the Judicial Department and the Finance Department of the Government of Assam. First, considering the above, this court fixed this matter again on 15th of May 2025, on which date both the Finance Department Commissioner, both the Commissioner and the LR, the Commissioner and LR of the Judicial Department, as well as the Commissioner and Secretary to the Finance Department, shall bring on record their stand by filing the affidavit. Failing to file such affidavit, this court shall construe that the contents of the instant writ petition that shall failing to file such affidavit, this court would be constrained to take recourse to the doctrine of non-frivolous.
Just one item one pertaining to Itanagar bench through BC.
Lordship, I'm appearing for respondent number 225, Your Lordship. I need some more time to file my affidavit. I've received a letter from the respondent number 4, Your Lordship. They wanted some more time, Your Lordship, to furnish Paravai's reply. Lordship.
So respond number 3. And 5, you are to file your
Lordship,
4 and 5 has not filed affidavit. Madam,
yes, Lordship.
why haven't you filed affidavit?
Lordship, I have not received any Paravai's reply. I have received a letter from the respondent number 4, and he has sought for some time, Your Lordship. He's praying for some more time to file, to furnish Paravai's reply.
Why is it
Lordship, may kindly give another 4 weeks, Your Lordship.
discipline
I'll file, Your Lordship.
work in that manner? This matter has been going on. You have been made a party. Directed to bring on record their stand by filing the affidavit on or before 23. So I've given you an adjournment. Twice I've given you adjournment. These things doesn't work in this manner. We impose a cost. Which one do you want? Cost or personal appearance? Which one?
Last chance, Your Lordship. Please, Lordship. Last chance may be given.
2 weeks, nothing more than that. If you don't file your affidavit, then we'll take it that you have nothing to say. We'll pass order appropriate. It is seen that by an order dated 11/2/2025, the respondent number 4 and 5 have been impleaded, and they were directed to bring on record their stand by filing the affidavit on 23/2025. On 28/3/2025, when the matter was taken up, the learned government advocate of the state of Arunachal Pradesh sought for an accommodation for filing the affidavit. This court, by the order dated 28/3/2025, granted a final opportunity to the respondent number 4 and 5 to file the affidavit. However, no affidavit has been filed Pusto. Ms. So-and-so appearing on behalf of the government of Arunachal Pradesh seeks for further accommodation. Pusto. Taking into account that on the last occasion a final opportunity was granted, comma, this court, and in spite of that, no affidavit has been filed, this court takes a serious note in the manner in which in the serious note of not filing an affidavit by the of not filing the affidavits by the respond number 4 and 5. Pusto. It is the opinion of this court that that if the respond number 4 and 5, Pusto. Accordingly, this court fixes this matter on 5th of June 2025. Pusto. It is observed that if by the next statement is filed by the respond number 4, comma, this court shall proceed with the disposal of the instant writ petition on the basis of the contents of the records, as well as also applying the principle of doctrine of non-preference. Next time, we'll pass the order, final orders.
Lordship, oblige Lordship.
Supplementary item 24 upgraded.
Move करना.
Revision under subsection 9 of section 83 of the WACOF Act. In this case, Lordship, the respondent has a plaintiff. Declaration that the suit land is a WACOF property and recovery of that from the defendant. That suit was allowed. Then we have filed a title appeal. It was reversed. Then it comes to the second appeal also. Second appeal also remanded back with the direction that the maintainability portion, I'll place that portion, Lordship, maintainability portion to be decided. By that time, Lordship, this WACOF tribunal has been constituted. So accordingly, it has gone to the WACOF tribunal and impugned order is accordingly passed.
Where is the impugned order?
Before that, Lordship, may I place the plain, because only two very small plain, Your Honor, Lordship. Only two paragraph plain is at Lordship 33 annexure 1. Here, if Your Honor see the post title itself, the Assam Board of
You are
WACOF,
appearing for whom?
I'm for the defendant in the suit.
Defendant.
WACOF tribunal has decreed the suit of the plaintiff. After remand, here, Lordship, kindly see the plaintiff at page 33 of the plaintiff, Assam Board of WACOF, Guwahati, through its secretary. Then defendant number 2 and 3, they have carried as in their individual capacity, though they have claimed to be mutawali in the paragraph. Now here, Lordship, kindly see the paragraph 2. Suitland is, Lordship, 1.5 katha of Dag number 19. Para 2. The suitland is part of WACOF property covered by Dag number 19, situated in so and so, so and so. The WACOF property is registered by the Assam Board of WACOF, Guwahati, under the provisions of the WACOF Act. Now here he claims the plaintiff number 2 is appointed mutawali of the WACOF property. The plaintiff number 2 is the president of Anjuman Khademul Islam Gwalpara, and plaintiff number 3 is the secretary of the Anjuman Khademul Islam Gwalpara. The Anjuman Khademul Islam Gwalpara, as a social and religious organization of the Muslim community, look after and manages, his word manages, mosque, graveyard, and other WACOF properties. The plaintiff number 2 as mutawali and plaintiff number 3 as the secretary of the Anjuman Khademul Islam Gwalpara are managing the work of property. 3, that the defendants have their residence on the contiguous waste of the work of property. The defendants taking advantage of the
No,
position.
no, Mr.
But-
Come to the impugn order.
Impugn order is at page 49. Annex 4. Issues are at page 54.
This is a judgment in the suit.
Yes, after remand.
Then
Now here, Lordship, some issues are not properly decided. Firstly, Lordship, this suit land is not a walk of land because we have specifically pleaded in our written statement, Lordship. If I may place that particular paragraph or specific denial, whether the plaintiff can discharge their burden to prove this. Para 3, Lordship, of our written statement, we have said that the Secretary of Assam Board of Waqf has no authority to institute the suit regarding maintainability. No resolution was passed by the said Waqf Board to institute the suit. Plaintiff number 2 is not appointed by the plaintiff number 1 as mutabali of the Waqf property in Gwalpara town. Plaintiff number 2 and 3 are unnecessary party in the suit. Then paragraph 6 also, Lordship. Suit land is not Waqf property covered by Dag number 19 of so and so. This suit land was never in possession of the plaintiff at any time. Defendant has been in possession of the same since 12/11/79. Now, Lordship, this, so far as Waqf property is concerned, Lordship, this only two documents has been exhibited in this case, Lordship. One is Sitha, Exhibit 1, and Exhibit 2 is the photocopy of the certified true copy of a order. On the basis of these two documents, Lordship, this issues has been decided in favor of the plaintiff. Now, so far as the Waqf property, Lordship, the suit land is not Waqf property for not registering as Waqf property under section 36(1) and 36(8) of the Act. Then, Lordship, Assam Board of Waqf did not delegate the power to the plaintiff to institute the suit as required under section 27 of the Act. Then, Lordship, plaintiff number 2 was not a mutabali as defined in section 3(I) of the Act, and also not produced certificate of appointment. So these are not there. So far as maintainability part is there. Trial court, tribunal has relied on this Exhibit 1 and 2 and decided this maintainability part in favor of the plaintiff. And there is a specific direction from the High Court, Lordship, at page 47 of that judgment of the High Court. The objection raised by the defendant in the suit as regard to maintainability does not appear to have been dealt with by the learned lower appellate court. The question of maintainability of the suit as raised by the defendants inextricably connected with the oral and documentary evidence adduced by the parties, particularly with regard to the absence of the necessary resolution authorization for filing of the suit. In such circumstances, I am of the view that the issue with regard to maintainability of the suit should be decided once again by the specifically considering the grounds, objections taken by the defendants in the written statement, and after due and proper appreciation of evidence that may have been adduced by the parties in this regard. So that due regard to this evidence is not there in the impugned judgment. And the many thing, Lordship, which are beyond pleading has been taken into account by the tribunal. Here it says suit land is described in the plaint as 1.5 katha of 31 bigha 2 katha 7 lesser. There is no pleading that suit land is 31 bigha 2 katha 7 lesser. There is no pleading. Lordship, there is a one direct perverse finding is that after perusing the pleading of the defendant, it appears to me that in their written statement, defendant directly admits that the land covered by Dag number 90 is a work of property. He did not admit. There is a specific denial. All those things beyond pleading taken into account. Your Lordship sees
Your
the
gift is by how? How is your gift?
gift by the uncle, Lordship, by registered deed is there.
Okay, then
Before that, Lordship is to see whether this land, suit land, is a work of property. To be a work of property, they have to comply with the provisions of the Act, Lordship. And they have exhibited only one photocopy, and it's exhibit 2. That is also photocopy, Lordship. And the contents also not proved, Lordship. No one is evident. In fact, Lordship, though the secretary is a, yes, Lordship. That Lordship will find that exhibit 1 and 2. In the file C exhibit 1 and 2, Lordship will find that page 11 to 13 and page 14. If your Lordship see the exhibit 1, the Lordship kindly see the in whose name is this patta is there. It is a government land, Sarkar. Sarkari Qabristan cannot be a work of property.
what is this?
Exhibit 1, Lordship. That Sitha, they have relied on Pottadarar Nam, Bapekor Nam, Jatin Nam, Sarkar. The Waqf is defined, section 3R of the Act. This is a government Qabristan. In the remark column, Lordship,
Page?
that Lordship will
It is one.
exhibit 1 at page 11.
Sita.
This is the Sitha. Now, Lordship kindly see Dag number 19, Dagor Kali, 31 Bigha 3 Kara 7 Lesa, then Pattadar Nam, Bapekor Nam, Sarkar, government Qabristan. Then remarks column, Muslim Qabristan. So it is not a work of land.
But isn't it required to be a Waqf property? You have to register it.
But it has to comply with section 3R.
No, one has to register it with the Waqf.
Yes, Lordship, that is a mandatory.
Where is the proof?
Lordship, kindly see motion. 36. 36 registration, Lordship. 1. Every Waqf, whether created before or after the commencement of this Act, shall be registered at the office of the board. Application for registration shall be made by the Mutawali. Now, this is prior to this Act. And what is the provision for prior to the Act? Section 8. Subsection 8, Lordship. Subsection 8 says, in the case of Waqf created before the commencement of the Act, every application for registration shall be made within 3 months from such commencement. And in the case of Waqf created after such commencement, within 3 months from the date of creation of the Waqf, provided that where there is no board at the time of creation of the Waqf, such application will be made within 3 months from the date of the establishment of the board. This is a sine qua non, Lordship. Then 37, maintenance of register is also required. The board shall maintain a register of Waqf, which shall contain, in respect of each Waqf copies of the Waqf deeds, when available, the following particulars, namely so and so, so and so, so and so, this. And the Waqf is defined, Lordship, at section 3R. There, Lordship, 37(3) is also there, correction of land records. On receipt of the details as mentioned in subsection 2, the land record office shall, according to the established procedure, either make necessary entries in the land record or communicate within a period of so and so, so and so.
37?
37 is the register, 37(3). So it has to be in the land record, but the land record they have produced clearly shows it's a government Qabristan. It may be managed by the some distinct your Lordship, but it cannot be constituted as a Waqf until and unless they doesn't show their registration, the register, because there is a specific pleading in our written statement. Now, secondly, Lordship, kindly see the exhibit 2, on the basis of which it has been said. Lordship, can you see that?
There is one more Waqf, Lordship, that is Waqf by user, Lordship. And registration certificate, we have already exhibited exhibit 2, Lordship.
Huh?
That is there. Exhibit 2 is there, Lordship.
What is that?
That is the registration certificate, Lordship.
We have only how many exhibits are there?
One
Only
and
two,
two,
Lordship.
1 and 2, Lord.
Huh?
2 is the photocopy, so they are raising objection, but the learned trial court held that at the time of admission of the document, they did not raise any objection,
Page
so
14,
that
Lordship.
admissibility cannot be
Page 14.
raised now.
Also from this document itself, whether it is a registration or not. Sita is at page 11 to 13,
Exhibit
Lordship.
2 is there, Lordship.
Exhibit 2 is at page 14, file C, page 14. Right after that, Sita, Lordship.
First is 11. Exhibit.
That is the order dated 20th September 1988.
Schedule below notified by the authority.
It's an order, Lordship.
Registration number is there, Lordship, 113, no objection received from any quarter. Alhaj Mohammad Mashraf Hussain, son of late Aftabuddin Ahmed, so and so in the district of Goalpara is appointed as Mutawali of the said estate, subject to the approval of the Assam Board of Waqf, Guwahati. And moreover, Lordship, the return statement, they are taking the plea that adverse position. Indirectly, they are admitting the title of the Qabristan, Lordship.
They've taken two pleas. One
Lordship.
is gift and the other is adverse.
Whether that was proved, Lordship, gift. Gift plea, whether they have proved, Lordship, that plea. By taking the plea of gift, Lordship, whether that was proved by the defendants.
Will come
And
later on.
they have taken the plea of adverse possession, meaning thereby we are the owner of the property, Lordship. They have clearly mentioned in their written statement, kindly see your Lordship. Annexure 2, Lordship. First in paragraph 8, they have taken that a plea of gift, Lordship.
Now, Lordship, I just place this exhibit to Lordship for a moment, Lordship. Lordship, kindly say this is an order. What it says, this schedule below as notified by the order dated so and so under office number so and so to all concerned is registered under the provisions of Central Waqf Act 1954. To date so and known as Muslim Qabristan kept preserved by the government for the said purpose. The registration number of the estate is 113. Then till this. Now it is whether this complied with section 36A. 36A is mandatory under this act. That it has come into effect from
There is
1196.
another provision, Lordship, Waqf by user, Lordship. Normally, Qabristans are registered as Qabristan Waqf, Lordship, by user. There is
Where is
3(1)(r), Lordship,
No, understood. Let us understand. What is the Waqf?
Waqf can be by using a Lordship also. That is in definition R1, Lordship. A Waqf by user, but such Waqf shall not cease to be a Waqf by reason only of the user having ceased irrespective of the period of such seizure. So as per section 3R,
Not on that. R1. By which Waqf means permanent dedication by any person of any movable or immovable property for any purpose recognized by Muslim law as pious, religious, or charitable, and includes a waqf by user. By such waqfs shall not cease to be a waqf by reason only of the user having ceased, irrespective of the period of such cessation. But the fact is, how can you give this particular property to waqf at all? Who are you? Who has created it?
Lordship, it was created long back, Lordship, and thereafter it was already used as a Muslim Qabristan Waqf property. Anjaman Khadimul Islam is the society who are, Lordship, looking after the property. And
Understood, but how did it come within the definition of waqf?
Lordship, by
Somebody
this
has to
order,
dedicate. Who is going to dedicate this?
without any dedication also, by user, Lordship, if a
No,
property.
and includes, you see,
That government property was dedicated to Muslim Muslim Qabristan, Lordship, and since.
by whom? Are you
Lordship,
saying that the government has dedicated, created the
Lordship.
waqf?
Lordship, Muslim Qabristan, it was earlier, it was a Pir Sahab, some Pir Sahab was there, Lordship. He dedicated the entire property in the name of Muslim people, Lordship.
But that is not your case.
No, Lordship, we.
How,
have
then
taken-
why haven't you changed it from government?
No, it is a Lordship taken a plea that it was registered under the Waqf board, wide exhibit 2, and thereafter, Lordship, the Anjumana Khadimul Islam is looking after the property.
Now,
Lordship.
if it is required, just for example, how do you take care of 36(8)?
That
In
is
the case of a
registration, Lordship.
waqf created before the commencement of this act, every application for registration shall be made within 3 months from such commencement. And in case of waqf created after the commencement, within 3 months from the date of creation of the waqf. So without this registration being done,
Lordship.
does the Waqf Tribunal have any business to do in, or more particularly exercise jurisdiction under 40?
But Lordship, this exhibit 2 proves that it was registered and registration number is also given, Lordship.
Understood. But after you filed a suit in the year 1996 when the Act of 1995 had come into being. So as on that day, isn't it required to be registered? Because if it doesn't say in the case of a waqf created before commencement of this act,
Lordship.
every application for registration shall be made within 3 months from such commencement, and in case of waqf created after such commencement, within 3 months from the date of creation of the waqf. Now, is it your case
So
out
it is
here?
not created constructed after 1995. It was created under the Act of 1954, Lordship.
So under 1954,
It was already registered.
before
Lordship.
therefore it says, is it say that if there is already been registered under the 1954, it is saved under the 1995 Act? Is it mentioned anywhere in the provisions?
Once a work-off, always a work-off, Lordship. Once a work-off property, it will always remain as a work-off property. It is settled law, Lordship. And it was already registered under 1954 Act, Lordship. So there is no need to, it says, Lordship, if the work-off is created after 1995, then again registration is required. But this work-off property was created long back, Lordship. And they admitted that facts in their written statement. Para 6, they have stated that the suit land is not the work-off property covered by DAG number 19 of the Chandaria as alleged in Para 2 of the plain. The suit land was never in possession of the plaintiffs at any time. The defendants have been in possession of the same since 12/11/1979. And before that, Lordship, Para 4, your Lordship, kindly see, the defendants have been occupying the suit land since 12/11/1979 as their own land, with knowledge of the plaintiff number 2 and 3. So they are claiming adverse possession, Lordship. They are taking two plea. One, there is a Lordship, there is a gift deed. In Para 8, they said that the real fact is that the suit land originally belonged to one Hasim Ali. His son Javed Ali gifted 2 Katha 10 lessa of land to defendant number 1 by a registered deed and gave her delivery of possession of said land. The defendant number 1 have been possessing the said land by erecting fencing on all the 4 boundaries. She constructed 4 houses on said land in the month of December 79, and she has been living there peacefully, continuously with knowledge of Anjumane Khadimul Islam. That is the plaintiff number 2 and 3 and its office bearers. But Anjumane Khadimul Islam does not represent the entire Muslim community of Gwalpara town. In recent survey, the said gifted land has increased as per her possession since 1979. She planted a mango tree in the suit land in the year 1979 and said tree is still there. So this is their case, Lordship. Their case is that it is adverse possession. That is why Lana Trial Court has said that they already admitted that this is a work of property.
On the basis of they claimed adverse possession.
Yes, Lordship.
Are they saying adversely we are possessing?
With the knowledge of the openly admitted, Lordship.
That is okay, but are they claiming adverse possession?
Yes,
That
Lordship.
our
Para
possession
7,
has become adverse.
Lordship.
Where?
Para 7, Lordship.
What do they say?
Even if in argument's sake it is proved that the suit land is covered by alleged DAG number 19, the plaintiffs have acquired right title and interest in the suit land by adverse possession. That the cause of action of the suit arose not from September 1995 but from 12/11/79. So they are saying that, Lordship.
So
adverse
this is done as a demur. This is not a direct plea of adverse possession, it's an alternative plea. They can very well take a contradictory plea.
But they have not proved that they have received the land, Lordship, by way of gift, Lordship. That was not proved, but we have proved our registration certificate, Lordship. Registration certificate already proved Chita is also there, Lordship. Plaintiff has already proved exhibit 1 and 2,
No, Sita only puts a remark only,
Lordship. Exhibit 2 says it was already registered under 1954 Act.
but it is after all a government land. How can there be a creation of a walk-off on a government land?
Normally it is.
Somebody has to dedicate. Who is dedicated? So
That
that
was-
has to give in somewhere, something has to be
That was
mentioned.
long back dedicated, Lordship, those were
Is
not
it anywhere
available in the
mentioned?
office. But it is mentioned that by Waqf Board, Lordship, referred that it is already registered. So, Lordship, that
Let
order
us see
was,
the 1954 Act. Now 1954 walk-off Act. You have a power under 40. 40 that walk-up board can very well make it a walk-up,
Lordship.
and that will be subject to a decision of the tribunal. Okay,
Lordship.
if you see section 40,
They are saying, Lordship, the Mutawali cannot bring a suit, Lordship, but Waqf board can bring a suit for eviction of the illegal possessors.
the board may itself collect information regarding any property which it has reasons to believe to be a Waqf property. And if any question arises whether a particular property is a Waqf property or not, or whether Waqf is a Sunni or a Shia Waqf, it may, after making such inquiry as it deems fit, decide the question. The decision of the board on a question under subsection 1 shall, unless revoked or modified by the tribunal, shall be final. But this is only subsequent there. What is the position prior to that?
Section 40, Lordship.
That is what I'm saying. What is the position prior to that?
Comparative table is there, Lordship, I think.
Station of Waqf is earlier at section 25.
Huh?
Section 25, registration.
That earlier. Now kindly come to section 6 of the old act.
1954.
Ah, this is a very interesting provision. If any question arises whether a particular property is specified as Waqf property in a list of Waqf published under subsection 2 of section 5 is a Waqf property or not, or whether the Waqf specified in such a list is a CR or Sunni, the board or mutually of the Waqf or any person interested therein may institute a suit in a civil court of competent jurisdiction for decision of the question, and the decision of the civil court in respect of such matters shall be final. So prior to 1995, whether it is a Waqf property or not, even if it is registered or not, that the civil court had the power to decide. Now what happens? The decision after 1995, as per 40, the decision of the tribunal becomes final. However, that can be overridden by the overridden by the tribunal. Okay. Now, here in a question, you sought for a property to be declared as a Waqf.
No, I have prayed for eviction of the defendants.
So without seeking a declaration under 54, and if we say 40 does not come because tribunal comes into the picture later on. So you see the Waqf, the board is being created under the board collected information. This will be done after the 95. So after 95, one can very well say, mere registration does not make it a Waqf property. But after 1995, not only a registration, the tribunal, the board has the power to say that it is a Waqf property. This is the fundamental distinction between section 6 and.
Accordingly, Lordship, by exhibit 2, this is a Waqf property.
How?
Already they have said that it was registered under the Waqf board, Lordship.
Therefore, I am saying, mere registration as per this act, if there is a dispute, cannot be a Waqf property. See this act.
But
section 6.
Lordship, the Waqf board has come for eviction of the defendants.
Understood. So now, therefore, there has to be a decision. Where is the decision?
If prayer number 1 is for declaration that suit land is part of Waqf property. That is declaration they sought in this suit.
So what you have done is, you have sought for a declaration that it is a Waqf property. On the basis of a document where you say that it is a Waqf property. And you see, therefore, how do you say about section 6 and read it with section 40 of the present act?
Civil court, if any dispute arises whether it is a Waqf property or not, it is to be decided by the civil court.
Civil court.
And that is final. Lordship.
That is final.
Yes.
Now what happens in 1940, 95 Act,
Section
the
50.
board has the power to declare a property as a Waqf property. But such declaration shall be subject to the outcome of the tribunal.
Here the power was given to the board itself.
Board, as per the 95 Act.
Yes, Lordship.
And that board, it is final unless modified or revoked by the
Okay.
tribunal. So this is, which happens post. Now what is happening out here in this case? You saying as a the board saying that it is a waka if
And
it is not registered under 36(8).
Right.
Means 36(8) makes it again coming within the ambit of the 95 Act. We are still under the 54 Act. So you say that we have not, or we also cannot look into that, taking into account there is no evidence to that effect. So here the board by himself considers it to be a
work of
Work up.
property.
and
And-
on the basis thereof, the court gives the declaration. This is the document on which it has given the declaration. The court could not have made the declaration being given on the basis of a document done by himself then.
That lordship, we tried to prove our case by, on the basis of exhibit 2. And court has.
You should have proved your
accepted.
case on the basis of this register.
We are saying that it is registered, so accordingly exhibit 2 was issued by the board. And on that basis, we are claiming that this is the work of property, now they are to be evicted.
So what is your basis? A basis which could not have been the basis, taking into account that as per section 6, it is civil court who could have given that declaration.
Lordship.
So there is
That-
no finality, unlike section 40.
But lordship, that civil court's power was given to tribunal.
No, I'm not on that. See, earlier, board had no power to declare.
Yes, lordship.
It can register, but it had no power to declare it to be a work of property.
Lordship.
It is a civil court's power. Now 95, the board has been given the power to do so, but that is subject to interference of modification, revocation by them.
By tribunal.
So therefore, the very basis on which the declaration is being given being exhibit 2, whether it is photocopy or whatever may be, that is wrong.
If the civil court has power to decide this is a work of property under 1954 Act, that power under 1995 Act was given to tribunal. And tribunal on the basis of that registration, which was earlier done under 1954 Act, take into consideration that this property is a work of property.
Absolutely, very well, it can do so.
Lordship.
There is no quarrel with that. It is not the question now the civil court has become the tribunal. There is no quarrel with that. I'm not
No.
on that. But the civil court or the tribunal bases its decision on a decision which cannot be a decision that it is a work of property.
They were incompetent under 1954 Act.
54.
Lordship.
They became competent only in the 1995.
But that was not done under 1954 Act. No declaration was obtained by the board. That can be lordship take, now they can take under 1995 Act and with the help of. tribunal.
1995, the board can take a decision
Lordship.
by calling for all these things. For inquiry, making inquiries, they can very well take a decision. And that decision will be final subject to the tribunal's decision.
Lordship.
But what the tribunal did, the tribunal came to a finding that look here, this is a work of property because of this document.
And even if lordship, we think that under 1954
Meaning
Act,
thereby a dispute is sought to be decided on the basis of the dispute.
but if, had it been a case under 1954 Act, lordship,
Then you have to go to the civil court.
civil court on what basis, lordship?
Dispute that this is a work of or not. If you need a declaration, it
Lordship.
is only the civil court who could have done it. See the language. If any question arises whether a particular property specified as work of property in a list of work published under section 5(2), which we have done, is a work of property or not, or whether the specified is the CR Sunne, the board, or the Mutuali, or the work of any person interested therein may institute a suit in a civil court of competent jurisdiction for a decision of the question, and the decision of the civil court in respect to the said matter shall be final, provided that no suit shall be entertained by the civil court after the expiry of 1 year from the date of publication of the list of the workup under subsection 2 of section 5. Provided further that in case of the list of workup relating to any part of the state and published or purporting to have been published after the month, such will be entertained by the year within a period of 1 year. For the purpose of this section, section 6A of the expression, any person interested or calling on the same code shall in relation to a property specified 55.2, another interesting thing. 6 will come when 5.2 is complied. Earlier act.
The board shall examine.
Board shall examine the report. On receipt of a report under subsection 3 of IMAN, the state government shall forward a copy of the same to the report. The board shall examine the report, forward it under subsection 1 and publish in the official gazette a list of workups in the state, or as the case may be, the part of the state, whether in existence at the commencement of this act or any coming under the year to which the report relates and containing such year. Now, where is that? That is the document. If we go by 5.2 also,
Publication, Lordship.
that should be the document of evidence. You could have argued that, look here, we have notified on the 5.2. There was no dispute raised by them then. And as such, by way of the first proviso to section 6.1,
But Lordship, there was no objection raised at the time of educing this
Understood.
document. Had it
I-
been
I
kept
am
with
un-
the raised objection,
Madam, I am completely in agreement with this order.
Lordship.
But can this order be said to be a publication in accordance with law?
But this document also says that no objection received from any quarter.
Understood?
So maybe it was published, Lordship.
No, no,
That
no,
one-
no. After publication,
Lord.
after you do it, this is being done prior to this. No objections were sought prior to this. And then this order was passed,
Right.
isn't it? Here is, and then publish as per 5.2.
19th September 88, it was registered, Lordship. Is registered under Central Work of 19, today, that is 19th September 88. And this order was passed on 20 September 1988.
Which order? 27.
This exhibit 2 is dated 29 to 1988. And registration was done on 19th September, Lordship.
So isn't it required for this to be published in the official gazette?
And as per 1954 Act.
And
Lordship,
if it is not published in the manner in which it is, that is the document which you ought to have produced it before the court.
the registration, sir.
Can this document be taken into consideration when you don't have the power even the board cannot declare that this is a, if there is a dispute, even the board cannot decide that.
But Lordship, in regard to walk-up property, there was no dispute. When we filed the suit for eviction, they raised that this is not a walk-up property, Lordship. We are saying that there are a big area is walk-up, the entire Muslim Qabristan is a walk-up property.
So what do you have to prove it? What
Only,
is the document you need to prove?
Lordship, and
First, you have to prove normally. You should have proved that there was a walk-off made by somebody, which you have not. Secondly, that walk-off was registered. So the registration certificate, registration has to be made. You have to prove it. Number three, let us state this. Number three is what you are required to prove is by way of an official gazette that there is a publication.
this exhibit two is notified after the day, Lordship, when it was registered 19th September 88.
Understood. This is 5.2. This seems to be done in terms with 5.2.
29, Lordship. Before registration, your Lordship saying before registration, it has to be published.
No, no, no. This is after registration.
This is after registration, Lordship.
After registration, this is after registration. You have already registered it. Therefore, you have a number. The number of the registration of the estate is 113.
Maybe, Lordship, this document says on 19th it is registered and no objection raised means, Lordship, it was earlier, it was published and thereafter no objection was received.
Cannot be so. You see here, you again see here, no objection raised here. Kindly see.
There is another date is there, Lordship can see the land
No,
schedule
no,
below
see
as
Section
notified.
4. Section 4 say, the state government may by notification in the official gazette appoint for the state a survey commissioner of workups and as many as additional assistants of the workups as may be necessary for the purpose of making a survey of the workup properties existing on the date as on the date of commencement of this act. Then let us know that the survey commissioner shall, after making inquiry as he may consider necessary, submit his report in respect of the workups existing at the date of commencement of this act in the state or any part thereof to the state, containing the following particulars, namely the number of workups in the state, the nature of gross income, amount, so and so, shall then, while making an inquiry, have the powers of the so and so. If during the inquiry any dispute arises whether a particular workup is a Shia workup or a Sunni, and there is a clear indication in the deed of the workup as it is nature, the dispute shall be decided on the basis of such deed. So this, the survey commissioner will decide it. The surveyor may by notification of the direct the survey commissioner to make second or subsequent survey of the workups in the state, and the provisions of subsection so and so shall comply in so and so, provided that no such second or year shall be made until the expiry of 12 years, 20 years from the so and so. Then this is how it is done. 4. Then comes 4, then you have 5. Publication of the list. On receipt of the report under subsection 3, that is the 3 is given by the survey commission.
Okay.
The state government shall forward a copy same to the board. The board shall examine the report. Because the survey commissioner is done at the behest of the state.
Lordship.
So they will submit it to the board, a state. The state will forward it to the board. The board shall then examine the report forward under subsection 1 and publish in the official gazette a list of workup in the state, or as the case may be, the state part of the state, whether in existence at the commencement of the act or coming into existence thereafter, to which the report relates, and containing such particulars as may be prescribed.
Before 19 September, it was notified on 3rd August 88, Lordship. It was already notified on 3rd August 1988. The first two lines, Lordship, the land schedule below as notified by the order dated 3rd August 88 issued under this official.
Isn't that the document which you should have placed?
Lordship, though, that was, they did not raise any objection, Lordship.
They did not raise an objection is different.
Lordship.
But how, that is the document which you have should have placed.
Lordship, it was earlier notified, then registered, then published, Lordship. But they did not raise objection. They are merely saying that, Lordship, this is not a work of property. So we have proved this document, Lordship. It clearly shows that on 3rd August, it was notified, 19 August, it was registered.
Understood, but can the court look into it merely because of this order?
And Lordship, this document is a public document issued
one?
by this Exhibit 2, Lordship.
So,
So Lordship, this is a public
how is
document,
it a public document? It is done by the Waqf board,
Lordship,
so it's a public document.
Lordship.
So can a public document be taken into account unless you call for the records? Isn't he exercising the similar jurisdiction, the Waqf tribunal, like a civil court?
Yes,
Then
Lordship.
what stopped him from calling for this original of this?
Lordship, that was not called for that, Lordship. Plaintiff already tried his best to prove his title, Lordship.
Huh?
Plaintiff tried his best to prove his title by exhibiting this document, Lordship. And tribunal taken into consideration that this admissibility of document cannot be raised later on, as they did not raise any objection at the time of exhibiting the document, Lordship.
Hold it on, madam. Person should have given additional evidence. You know the other side has been fighting tooth and nail. Huh?
Today I have filed this IA for Lordship, the plaintiff number 2 and 3 already changed, Lordship. So I have filed this IA. On last occasion, they raised objection about the substitution of the plaintiff number 2 and 3. So your Lordship fixed that this is an old matter, so to be taken up on 8/5. Last occasion, there is an order that this is a very old pending matter, Lordship.
And I have serious doubt, madam, as to how government land there can be a Waqf created. Somebody has to dedicate. Who is dedicating it? The government.
No, Lordship, it was.
Somebody has to dedicate. Is it heard of?
Those Waqfs were created long back, Lordship, the year 19.
Maybe, whatever may be, they may have given it. You should have got it from the government for allocated to this Kobostan. You have kept it government land and then this was done. They are only
But
there
it
for half bigger, half katha,
2 katha, 10 lesser, Lordship. They are occupying 2 katha, 10 lesser.
out of 3 kathas. 3 kathas, 7 lectures.
Our plain schedule says, Lordship, 1.5 katha. 1.5 katha, Lordship.
So that is your schedule. So you
Yes.
are asking for 1.5 kathas.
Yes, Lord.
So what is happening to the remaining 19 bighas?
Muslim Kobostan.
You have put the schedule of entire 19 bighas containing an area of 31 bighas, 3 kathas, 7 lectures. Then how did you prove that this area falls there?
No, I have, the schedule says, Lordship, only 1.5 katha.
Then I understand. How do you say that this falls within that? On the basis of the cheetah. The entire 30, on the basis of the cheetah says dark number 19 contains 31 bighas.
Yes, Lordship.
That is your basis.
31 bigha is a work of property, Lordship.
Yes.
Not, there is a mention of part of work of property with houses there and occupied by tenant of the plaintiff.
Huh?
Not, there is a work of property, Lordship.
Forget
south
about
is
that. I'm not concerned with their case, whether they have succeeded or not. But the question is, did you prove it that it is a Waqf property? And once it is outside the Waqf, the court, the finding of the learned trial court is wrong, as it is outcome. The court immediately loses its jurisdiction for other consequential reliefs.
I'll go through that 1954 Act, Lordship. The 1954 Act So far, Lordship, six is saying, section six. Lordship may take it tomorrow, Lordship, at 2 p.m.
No,
again.
tomorrow. I've given you enough time. Spend 1 hour. So we should dismiss it. Allow it to be.
Lordship. Your Lordship.
You
already-
have mentioned the matter. You know this is not a good code to do this type of.
No,
matters.
Lordship. I am happy that it will end here, Lordship. This is a good code to be decided all the questions, Lordship. There are so many complicated
So
questions.
there the problem arises, madam. Let us assume I'm not on, therefore I'm not on he's saying that the suit can be filed. These are first appeal business. I'm in 227 if I'm not wrong.
Yes, 227.
So my therefore the question is on the question of it is shocking. So here the court had passed the award on the basis of a document without that being the conclusive piece of evidence. Is the only problem.
Your Lordship's power is wider than the section 115 CPC of 227 because liberal and positive,
Which one?
the jurisdiction under subsection 9 of 83 is wider than the other revisional jurisdiction, Lordship. In this case, Lordship can even appreciate the evidence also, question of facts also.
Here,
Yes, Lordship.
this is done under
Under subsection 9 of
83-9 proviso,
83.
Lordship.
it is a
83-9.
83-9 proviso.
proviso.
That
No
is
appeal shall
revisional
lie
jurisdiction.
against an order decision otherwise
High
at
Court
the
can on
interim or
its
otherwise
own
given,
call
provided the
for the
High Court
records.
may on its own motion or an application of the board or a person aggrieved call for and examine the records relating to any dispute, question or other matter which have been determined by the tribunal for the purpose of satisfying itself as regards correctness, legality or impropriety of such termination as may confirm, reverse or modify or
83-9 says no appeal shall lie against any decision.
This is interpreted, Lordship, in 2019-16 SSC page 1, paragraph 7. It says, Lordship, High Court may also examine the correctness of the findings of the fact, reapprise the evidence, because it is a positive, in a positive liberal approach is there, since the appeal is not there. So Lordship can even appreciate the evidence and better the finding, unlike the
and who gave evidence on behalf of one?
none.
Lordship, Waqf
Except
board.
the signature, there is not even verification. Only one page he is signed. Then no. Even the second appeal, Lordship, he is, second appeal also, he is not a party, he is a pro forma respondent. This plaintiff number 1.
Is it?
First step was
Lordship.
taken by the board
Lordship,
and thereafter, Lordship, we are fighting. The board is not coming.
Those things are argued.
And today,
Today I am for 2 and 3 only.
what about one?
One is Lordship Standing Council, normally Waqf board. They did not appear.
Oh,
Only signature is there in the plain first page. That is the thing.
For
Nothing,
that,
no
Lordship, I
involvement.
have filed this IA
That
for
letter
Lordship.
so
on-
this is not a suit by the board.
Only the plaintiff name is there, Lordship. Assam Board of Waqf represented by secretary. Only one signature is there, even no verification, not each page is signed, no evidence is given. And this exhibit is not proved by this author. Truth has to be proved, Lordship.
To do. Anything more is required.
Pass order. We know that a reason order.
Let me come back.
Lordship.
I think it's high time, this litigation has to close.
Lordship.
Heard Mr. J. Dekar, the done counsel appearing on behalf of the petitioner. Miss so who appears for the respond number 2 and 3. 2 and 3. None appears on behalf of the respondent number 1. The jurisdiction under proviso to section 9 of section 83, subsection 9 of section 83 of the Waqf Act 1995, for short, the Act of 1995, have been invoked to challenge the legality, correctness, and validity of the judgment and decree dated 17/5/2008, passed by the presiding officer, learned presiding officer, Waqf Tribunal, Guwahati, for short, the Learned Tribunal, in WT case number 1/2007, bracket title suit number 59/1996. Post. The brief facts which led to the filing of the instant proceedings is narrated infra. Next. For the purpose of convenience, the parties herein are referred to in the same status as they stood before the Learned Tribunal. Full stop. The respondent numbers 1, 2, and 3 herein joined together to file a suit being title suit number 59/1996 before the Learned Munsif number 1 Gwalpara against the petitioners herein, seeking declaration that the suit land is a part of the Waqf property, semicolon, for possession of the suit land by evicting the defendants and by demolishing and removing the houses and structures standing thereon, for permanent injunction restraining the defendants from possessing the suit land after the defendants are evicted from the suit land in due course of law, semicolon, for mean profit, MESNE, profit at the rate of rupees 50 per month from the date of institution of the suit till the defendants are evicted and possession is delivered to the plaintiffs, and for cost of the suit. The case of the plaintiffs is that the suit land is a Waqf property covered by Dag number 19, situated at Chondoria under Balizana Circle in the district of Gwalpara. The said property, as per the plaintiffs, was registered by the Assam Board of Waqf under the provisions of the Waqf Act, and the plaintiff number 2 was the Mutuwali as of the said Waqf property, as well as was also the president of Anjumane Khademal Islam, Gwalpara, and the plaintiff number 3 is the secretary of the said Anjumane Khademal Islam, Gwalpara. It is the case of the plaintiffs that the defendants have their residence on the contiguous west of the Waqf property, and taking advantage of the position, in the month of September 1995, trespass into the suit land, which is a Waqf property, and constructed 2 thatched houses therein. And since then, the defendants have been possessing the suit land as trespassers. On the basis thereof, the said suit was filed seeking the reliefs as above mentioned. The defendants joined together and filed a written statement alleging raising various preliminary objections as regards the maintainability of the suit, and more particularly, that the Secretary of the Assam Board of Waqf has no authority to institute the suit and there has been no resolution passed by the plaintiff number 1 to institute the suit. On merits, the defendants had stated that the suit land is not a Walker property and that they had been possessing the said suit land. On the basis of a registered gift executed by one Javed Ali in favor of the defendant number 1. It was further mentioned that after the execution of the said gift deed, the defendant number 1 constructed 4 houses on the said land in the month of December to 1979, have been living and thereupon have been living peacefully, continuously, with the knowledge of Anjumali Khadam Islam and its office bearers. The learned civil judge, the learned trial court, the learned civil judge, junior division number 1, Gwalpara, which was the trial court, decreed the suit in favor of the plaintiffs by the judgment and decree dated 23/8/1999 against being aggrieved. The defendants preferred an appeal before the Court of the Civil Judge Senior Division Gwalpara, which was registered and numbered as title appeal number 3/2000. The said appeal was allowed by setting aside the judgment and decree passed by the learned trial court, vide a judgment and order dated, judgment and decree dated 28/6/2000. Being aggrieved, the plaintiffs preferred an appeal before this court, which was registered and numbered as RSA number 154/2000. The coordinate bench of this court by the order dated, judgment and order dated 8/12/2006 interfered with the order, judgment and decree dated 28/6/2000 passed in title appeal number 3/2000 and remanded the suit for a fresh decision. First, it is relevant to take note of that when the order dated 8/12/2006 was passed in RSA number 154/2000, the Waqf Tribunal was constituted And accordingly, by virtue of Section 85 of the Act of 1995, the suit was remanded back to the state tribunal for a decision afresh. In the backdrop of the above, it is relevant now to take note of that based upon the same pleadings, based upon those pleadings, the learned trial court, that is the court of the civil judge, junior division number 1 at Gwalpara, had framed 9 issues, which are reproduced hereinunder. Additionally, on 15/3/2008, another issue was framed as issue number 3B, which also is reproduced hereinunder, page 54 Tepago, huh? The learned tribunal, by the judgment and order dated, the judgment and decree dated 17/5/2008, decreed the suit in favor of the plaintiffs, holding inter alia that the suit property was a part of the Waqf property covered by Dag number 19 of Chandoria Pathar, Balizana Circle, Gwalpara, semicolon, for recovery of khas possession of the suit land, thereby evicting the defendants, their men and agents from the suit land, and by demolishing the houses constructed thereupon, semicolon, for mean profit at the rate of rupees 50 per month from the date of institution of the suit till full satisfaction of the decree, as well as for permanent injunction restraining the defendants, their men, agents from entering into the suit land after delivery of khas possession to the plaintiff. Issue number 6. Is of vital importance for the purpose of deciding the instant dispute. Inasmuch as the said issue pertains to as to whether the suit land is a Waqf property and the defendants trespass into the suit land in September 1995. It is seen from the discussions so made by the learned tribunal, that the suit land has been held to be a Waqf property merely on two documents, that is Exhibit 1, which is a copy of the Chita, CHITHA, pertaining to Dag number 19, and Exhibit 2, being an order dated 1988 of the Secretary of the Board of Waqf, Assam Board of Waqf. It is on that premises, the subsequent reliefs have been granted, the other issues have been decided. In the backdrop of the above, let this court therefore take note of the submissions so made by the learned counsels appearing on behalf of the parties. Mr. J. Teka, the learned counsel appearing on behalf of the petitioners, oblique the defendants, submitted that taking into account the definition of Waqf as defined in Section 3R of the Act of 1995, a government land cannot be a Waqf property, or for that matter, there cannot be a creation of a Waqf on a government land. Referring to Exhibit 1, the learned counsel submitted that it would be seen from the Chita that Dag number 19 belongs to the government. And as such, it does not fulfill the requirement to be a Waqf within the meaning of Section 3R of the Act of 1995. He further submitted that the other document on which the learned tribunal had arrived at the conclusion that the land in question was a Waqf land is on the basis of a photocopy of an order dated 29/1988. He submitted that in terms of Section 36(8) of the Act of 1995, as the Waqf was created before, allegedly said to have been created before the commencement of the Act of 1995, the property was required to be registered within 3 months from the date of commencement of the said Act of 1995. Further referring to Section 37(3), the learned counsel submitted that the Land Records Office shall make necessary entries in the land records or communicate within 6 months from the date of registration of the Waqf property, which have also not been done in the present case. He therefore submitted that as there was no registration done in terms with section 36(8), the learned tribunal committed gross error of law in arriving at the finding that the land in question was a Waqf land, Waqf property. The learned counsel for the petitioners further submitted that though the Assam Board of Waqf is the plaintiff number one, but accepts signing on the first page by some person as secretary of the said Waqf of the plaintiff. They have never participated in the said proceedings till date. Isn't it?
They did not produce any evidence on.
They did not participate anywhere. Here also we don't see the word this fellow,
Sometimes they appear, their name also appeared earlier, council's name,
except filing wakalat numbers by the councils.
on merit. And also one thing is that the RSA is filed by plaintiff number 2 and 3, not all by the all plaintiffs.
It's okay now.
Published.
And he further submitted that this aspect would be very clear from the very perusal of the name of the parties in RSA number. (154/2000), wherein the plaintiff number one have been arrayed as a performer respondent in the said appeal filed by the plaintiff number 2 and 3. Per contra, Ms. R. Chaudhary, the learned counsel appearing on behalf of the respondent number 2 and 3, submitted that the land having already been registered as a Waqf in terms with the Waqf Act of 1954, there was no requirement of a fresh registration in terms with the Waqf Act of 1995. In view of section 112 of the Act of 1995, which saves all things done under the Act of 1954. The learned counsel further submitted that by Exhibit 2, no, this is 2. Exhibit 2. It would be seen that the land in question, the suit land in question, is a part of the Waqf property. The learned counsel submitted that though the counsel appearing on behalf of the petitioner had submitted that the said Exhibit 2 is a photocopied document, was a photocopy and not the original placed But there was no objection so raised at the time when the Exhibit 2 was tendered in evidence. And therefore, there was no bar on the part of the learned tribunal to decide to accept Exhibit 2 as a valid evidence for the purpose of deciding the title over the plaintiff of the plaintiffs. Anything more? I've heard the learned counsel appearing on behalf of the parties, and I have given my anxious consideration. First, taking into account that the claim of the plaintiff is based upon a waqf being created prior to the coming into commencement of the Act of 1995. This court finds it relevant to take note of some of the provisions of the Act of 1954, which was holding the field when Exhibit 2 was issued. Chapter 2 of the Act of 1954 deals with survey of waqfs. Section 4 of the Act of 1954 relates to preliminary survey of the waqfs and how it is required to be carried out. It will be seen from a perusal of subsection 1 of section 4 of the said Act of 1954 that the state government, by notification in the official gazette, appoint for the state a survey commissioner of the waqf and as many additional or assistant survey commissioners of waqf as may be necessary for the purpose of making a survey of the waqf properties existing in the state at the date of commencement of the Act. In terms of subsection 3 of section 4, the survey commissioner shall, after making an inquiry, submit its report in respect of the waqf existing at the date of commencement of the Act in the state or any part thereof to the state government containing various particulars. In terms with subsection 6 of section 4, the state government may by notification in the official gazette direct survey commissioners to make second or subsequent survey of the waqf properties in the state, and the same shall be done as per the mandate of subsection 2, 3, 4, and 5 of section 4 of the Act of 1954. Section 5 of the Act of 1954 is of importance, taking into account the dispute involved. It stipulates that the survey commissioner's report shall be forwarded to the board, and the board shall examine the report and publish in the official gazette a list of waqafs in the state, or as the case may be, the part of the state, whether in existence at the commencement of the act or coming into existence thereafter, to which the report relates and containing such particulars as may be prescribed. Section 6 relates to disputes regarding a waqaf. A perusal of subsection 1 of section 6 stipulates that if any question, any dispute arises as to whether a property, particular property is a waqaf property or not, which is specified as a waqaf property in a list of waqaf published under subsection 2 of section 5, the board, board or the mutuali or the waqaf or mutuali of the waqaf or any person interested therein may institute a suit in the civil court of competent jurisdiction for decision of the question, and the decision of the civil court in respect of such matters shall be final. It is further seen that by the Waqf Amendment Act 1984, the power of the civil court had been taken away and conferred upon the Waqf Tribunal in terms with section 6A. Be it as it may, it may not be out of place to mention that there was no Waqf Tribunal created and as such, the civil court exercised the jurisdiction.
1954, Your Lordship.
Huh?
Under 1954.
This court further finds it relevant at this stage to take note of the Act of 1995, wherein power had been conferred under section 40 upon the board to make inquiry and to pass a decision as to whether a property is a Waqf property or not, or whether the property is a Shia Waqf or a Sunni Waqf. And such decision is final unless revoked or modified by the tribunal. First, admittedly, in the instant case, it would be seen that there was no registration so done in terms with section 36(8) of the Act of 1995. And there is also no decision in terms with section 40 of the said Act. holding that the land in question, the suit land in question, falls within the Waqf property. The only document on the basis of which it has been claimed to be a Waqf property is the order dated 1988. In the opinion of this court, Section 5 or even Section 6 of the Act of 1954 does not conceive of an order as of an order to be passed by the board in terms with board. The finality attached to as to whether a property is a Waqf property or not could have been only arrived at on a perusal of the list published in the official gazette in terms with Section 5(2) of the Act of 1954. Or if within 1 year any dispute had been raised before the civil court, a decision of the civil court. Nothing was placed by the plaintiffs before the learned tribunal to arrive at a conclusion. Nothing was placed. There is no evidence placed by the plaintiffs. To the effect that there was a list so prepared in terms with Section 5(2), which was published in the official gazette, which would have been the conclusive evidence as regards whether the suit land was a Waqf land or not. Without this vital evidence, the learned tribunal could not have arrived at finding that the land in question was a Waqf property. Next. This court further finds it relevant to take note of another very vital aspect of the matter, that there is also no materials shown in the evidence as to how there was a creation of a Waqf in terms with Section 3R in respect to a property belonging to the government, as is admitted, as is the admitted case of the plaintiffs from Exhibit 1. Though Ms. R. Chaudhary, the learned counsel, submits that there can be a Waqf by user, as defined in subsection 1, Roman 1, subclause Roman 1 of Section 3R of the Act of 1995. There is no evidence led to that effect also. And further to that, the learned trial court also, tribunal also did not take note of the said aspect. It is the present case, in the opinion of this court, is a glaring example whereby the learned tribunal have declared the land to be a Walker property on the weaknesses of the case of the plaintiffs, of the defendants, which goes very much against the well-settled principles of law. Next. This court further finds it relevant to observe that as the plaintiffs have failed to prove that the land is a Walker property, or for that matter, the plaintiff number 2 or 3 has any right over the land, comma, the question of granting the reliefs has been granted, reliefs as has been sought for in the plain does not arise. Considering the above, this court is of the opinion that the impugned judgment and decree passed by the learned, dated so-and-so, passed by the learned tribunal in title suit number so-and-so, in WT case number 1/2007, cannot be sustained in law for which the same is set aside and quashed. Full stop. The petitioner herein shall be entitled to cost throughout the
Deeply obliged.
Admission. Admission fees, name, no? It is student, orders to the student.
Item 8.
Director to produce the record. This is related
Oh,
to
driver,
driver.
Everything. We have it.
who is he?
Who's coming in?
You file affidavit.
Yes, Lord, we have time.
Yes, who is he, driver?
Lord, I have got the record, my lord will kindly inspect. It has got the resolution book and the driver selection record. The only issue is that whether marks given by the interview board to the respondent, whether that is excessive or not.
Not that is not the issue. The issue is how much marks did you fix initially?
It's 60. For interview, 60.
Oh, initially.
Initially, it was not fixed.
So
In
you
the
fix it
advertisement,
after
it is, in the advertisement, it is said that they'll have to undergo driving test and viva voce. The MBI Miller on his own created another column, signal test. So he calculated 70 plus 30. Out of that, he gave 55 to the petitioner.
What is the name of the respondent?
Shankar Das.
Who is Hafizur Rahman?
Hafizur Rahman is another person who also scored marks.
Biplab Das? A?
Not selected. The petitioner is serial number 8,
What is the name?
Parvez Ali Ahmed. Without any allegation of malafide or all against the selection committee,
Where is that one? Yeah, Parvez Ali.
Ali,
No, he had only 2. A signal and driving skill test.
yes, this, the,
M is 30. This marks is 30 and 70. So
Song,
you asked him to do it without You ask these people to do it without fixing how much marks you have to do it.
Look, in the advertisement, it is not required.
I'm not on that.
Yes.
You are referring this candidature to these people. So have you not instructed them
No, the instruction was you hold a driving test
for how much marks?
total marks. It
Huh?
was not said. It was not said. He on his own,
How is it possible?
no, even assuming, Milord, the MBI gave 70 marks for driving test.
No,
It was fine.
no, he gave 100 marks.
70 plus 30,
I mean, driving
30
skill is 30,
70
70
and
and 30,
signal test is 30.
30. Then
Our contention is that this signal test, it is his own creature. We only said for driving test.
but did
Fine.
you say 70? Did you tell him that out of what you have to do it?
No, record doesn't
Isn't
speak
it
so.
your requirement?
It's true, it's a requirement, but doesn't
Then
say so.
what
Even
is it?
otherwise also, Milord, 70, he has given, out of 70, he was given 45 and I was given 30. And if your lordships compare this column of driving test, nobody got more than 40. He was the only person, petitioner, he got 45. Nobody got. 9 candidates participated, all are between 30 and 35.
So therefore you had
And-
60 to make it there.
No. It's not
Otherwise,
like
why was 60 necessary?
60
That's
was
the only way to differentiate. Otherwise you have to give him
So
0.
that a perception lordship can have always, but the thing is that my record says 20 marks, three selection committee members, 20 marks divided between them and they gave the marks. There were 3 committee members who took the interview. Each member was given 20 marks. That is there in the records. That we have formed a committee and each member has been given 20 marks to award.
Always.
No, whether,
Wait.
I'm sorry,
He is Biplab. What was his name? Shankar.
Concord. And it's not the case that selection committee only gave the mark to the respondent. Milord, the serial number one,
How many
Hafizul also
selection committee is there?
3 members.
Huh?
Sorry, Milord,
3 members.
3-member selection committee. No malafide against, LA has been alleged against the selection committee
Okay,
members.
What do you do to give so much mark? What questions do you put?
No, that is not there, Milord.
I'm asking
But-
you.
Yes, normally, Milord, driver of a judge,
One thing, there is a subjective satisfaction here, objective satisfaction. They have universally given him 18,
18. No, Milord, in all the cases, we cannot come to such conclusion, Milord,
Not
in all the
necessary.
cases, but driver of the judge, it involves many things apart from driving the car, Milord.
Is he driving the judge for somebody?
No. I have
Then
seen,
How do you know that he will be a good driver of a judge?
the selection committee has got the expertise.
How is it
Milord, they
possible?
they may put questions.
Tell me, let us also know how we can hold.
Milord,
that good-
Lordship will know
I don't
better than me. Your Lordship will know better than, much
No,
better.
I'm not there in the selection committee, but I'm asking you,
No,
what are the requisites of a driver of a judge?
apart from being a driver, Milord, driving skill, there are other skills also, Milord. Punctuality, demeanor, and all these things are there. In fact, some of the qualities I have mentioned in the affidavit, that it's not only the driving skill, the other factor. And in the absence of any allegation of malafide, what is the scope for interference?
Not malevolent, don't worry, interference is done on a proper way.
No, that is my submission, Milord. If they have filed a case and they have leveling allegation that exerted marks were given to the selected candidates, there has to be some foundation for that. Not that the one person was the selection committee and he can choose or he may have some inclination. There were three members.
That's like in the morning case, as I was telling you, no? 20, what is 24, 34 and 10, 30. And we have given 29.32. And there is no mention that all the marks would not be added up together. Remember,
Average.
average is not there, but we have taken the average. Here they have taken it
Average.
as per no average. Everybody's marks have been given.
20, yes, out of 20, they have given mark. And it came down to 55 in respect of respondent, 20 in respect of the petitioner.
Age limit? There's no
40.
age limit? 40.
40.
Huh?
40, as per, I'll just cross check now.
40 for drivers?
Yes, my lord, 40 years as on 31/12/2023.
40 years.
40 years,
As on
31/12/2023.
your client name is Parvez.
Yes, it will be 39 years, 9 months,
How?
19 days.
His date of birth is 31st of March 1982.
Yes. That will come on the date of the advertisement.
No, no,
39
as on that particular date is being given. Mr. Das kindly make it. Is of 31st of March, September, July 1982.
It became 22, 40 in 22.
As on the date of the advertisement, 39 years, 9 months,
No, it can't be.
Date of the advertisement is 16 August 23.
Yes.
Then. So he is not qualified. Age cross. This is as per your driving license. I hope your driving license is proper.
Huh?
See the date of the
31
driving
P.
license, date of birth.
His HSLC certificate is.
I am not concerned. We will go by the driving license. You are a driver.
Yes.
No case. Why should we interfere?
Yes.
See? By this.
In fact, he has annexed his driving license also. Annexure 2, page 16. It says 31/7/82.
That is why I am saying.
Exactly.
None of you have looked into it.
So sorry. In fact, in certificates,
31/7/82.
our birth are given age as on so and so.
Advertisement of it one.
31/7/82.
82. If it is 82, then my learned friend says, 39 years, 9 months, 9. I'll have to calculate.
How is it?
I'll have to calculate.
2022.
Can't be. If it is 23, it can't be. Once you have 82,
Yes.
on July 1982,
82, 92, 2002, 2012, 2022.
is 40 years
40
completed.
years.
22.
31/7,
22,
2022, 40 years.
advertisement is 25,
23.
22. For advertisement. Advertisement says as on 1/1/20.
Is it say?
No, no, as on 31.
As on 1/1/20, page 19 last.
See?
19 last, 7.
19. One second.
19, last sentence.
One. 39 years.
39 years, 9 months.
So he
Yes.
comes.
Stands corrected, yes, ma'am.
Otherwise, they would have rejected me there.
Huh?
Otherwise, they would have rejected me there. itself.
Oh, this is a different advertisement, Mr. Das. you are
Yes,
reading.
sorry. Sorry, my apologies, my lord. This is a
Could be.
separate and different as well, advertisement.
And what is this advertisement at page?
That is the Guwahati High Court, my lord.
No, the another Madhuli one, page 25,
Page 23.
5/8/2024. It is another one, na?
This is a separate advertisement. They annexed this to demonstrate that in the advertisement itself, the marks, what marks will be in which component that has been given.
No. Anything you want to say? I am going to allow his repetition.
Judgment, I'll just like to place for lots of consideration. Last occasion, my senior placed one judgment. Vishnu Biswas regarding my lord, allocation of more marks in interview. That 60 marks. Lord, if we consider 60 out of 160, then it comes 37.5. So it's not excess. In Jaswinder Singh Milot, that judgment relied on my senior, that was distinguished. Para 2 is the facts.
No, I'm not going on this line only. I'm going on the line that you did not fix it initially. You fixed the 60 marks only at the time after knowing what are the marks obtained in others.
Milord, where is the
Which
wrong in
makes it
that?
100 marks.
Milord, where is the wrong in that?
How can you? And therefore he has got 55.
It's, your lordships is appreciating that after seeing the driving marks, you have
Then you
made up
have
in
fixed.
mind that we don't want
Then
to
you
give
want to
him,
do the viva
we don't want to give him, so we segregate marks 20 each, make it
No,
60.
I'm not on 28. You are putting it in 60. Why? What was the necessity for making it 60?
Look, 60 is out of 160. It's
Because
not
if you
100.
have 50, you can't. Are you going to give a person who is getting 70 two each? You have to give 2 marks each or 3 marks each. If you give 50,
Lordship will kindly appreciate, 70 was not fixed by us.
understood. So
I
if
will-
you have not, the entire proceedings goes. You can't have a selection that you say that okay, you do it, and after coming to that, oh, marks have been given, now we'll have it like by 60. What is the
That,
basis?
my lord, that something, there is something wrong that the
That is
concerned
wrong. You
judge
can't
should
have
have
it.
at least said
And
the,
it's surprising this court. How is it every person is given 19 without taking his driving test?
has to-
Only on demeanor. Educational qualification same. Only on demeanor. And you say on the basis of 104 driving. He drives 104. What does he drive? What do you drive? You got your driving license only in 2011. What do you drive? Mr. Khan, what have you been driving all this while?
But I have no instruction as to whether he has, he is driving.
I'm not concerned about him. You.
Well,
You have your instruction for yourself.
but I am saying to the Lordship in respect of the response number 6, Lordship. And that I have no.
What did you drive?
What vehicle he is driving, I have no instruction on.
so that portion is, yes, the concerned judge, when sending requisition to the DTO, should have
You should have
said,
fixed it. How much marks you are going to give this person, this much, this much. This is how it is to be done. You
yes,
have to
how
know
much
it.
in driving, how much in viva voce, at least.
Then later on, after knowing what is the marks out there, makes it unfair. And to have, it is more like 100% marks now.
55 out of 60.
No. Now we want to do it 60. Why? What is the justification of 60?
Look, perhaps there is no requirement of giving any justification. I'm
No,
saying
I'm not. And why not 80?
it could have been 80 also.
Why not? 60 makes it very clear because he needs 55.
No, it could have been 80 also, but it could have been, my lord, 10, 10, 10 also, 30 also. My lord.
No. 30, he can't.
No,
He
no.
needs 55.
Yeah, no,
No,
appreciated that.
Ah.
But one thing,
you see, he is 70. How do you overcome him?
that is the thing your lordship says.
How do you
appreciated.
overcome
That-
him? You have to give him minimum 20 because others also you are giving 20. It's minimum something. You have to give him minimum 20.
But I
Okay.
will not, I will
So
not
make it
comment on
90
this,
for him.
but
So how do if you make him 90, how do you throw him out?
that's true. If
This
Not-
type of things one cannot. You will say what is there? Demeanor Okay, you have it, fix it, do it properly. If it was the state government, we would have jumped in today. How is it possible you are doing?
One thing is correct, your worship is absolutely correct that they should have fixed the marks. There is no, there is
What
no
matters? This
doubt
has been
about it.
done out there. Chalo,
My lord,
I'll allow his petition. Yes, what do you have to say?
just lordship, I have raised three points lordship regarding. My lord, admittedly, lordship, he has been given high marks in two tests, that is driving test and signal test. Nobody has raised any objection.
No,
This
that is also wrong. I'm not saying that he's right. You see, therefore, I am not saying that he's been given 70 is good. You are giving like 70 being given wrong, 55 given to you is also wrong. The reason why it is to be right is you should have fixed marks, how much is to be going and when. It is only when these people came to know that look here, he has got 70 and you have got only 40. So how do you take care of him?
Look, in the event also, there could have lordship less than 60 marks, say it is 50 marks.
Understood? Why didn't they fix it?
That is up to the,
Therefore, I
Authority.
have nothing to do with you.
my lord.
I'm only asking him. Why did they not fix it? They fix it subsequently. We'll give 60. What is the justification? Except giving you 55.
That part lordship, they,
Are you such? I'm not saying that he is good. But are you such that you have to be given 19, 19, 19?
can be, one can give, but admittedly,
He
lordship, they
has
have not,
been given 70 out of 100.
yes,
He has been given 70 out of 100.
out of 100,
You have been given 45 out of 100, 40 out of 100.
40.
See, there's a difference of 30, but then also there is still a difference of another thing. But your and their Viva Voce marks is something to that effect, which makes it 55 out of here. I'm not going to give it to him. But the entire thing has to be struck off. Let them go for a fresh election.
No, they have not, admittedly, they have not challenged the advertisement, and they have lordship participated in the selection process in a calculated manner. And when the lordship come out unsuccessfully, they raise that plea. Well, at my humble submission, the lordship to that effect, there are decision of the Supreme Court lordship, I am relying to judgment.
You want to refer to Madan Lal?
My lord.
Madan Lal. And which one?
One is Madan Lal and another one is Ashok Kumar and another.
Makes no difference out. Taking into account, he's not challenging the selection proceedings. He's challenging the question that what is the basis on fixing this 100 marks at a later stage?
But he had participated fixing 100 marks in the driving test and signal test, and subsequently lordship in the Viva Voce.
Did you inform him that we are going to have it in 60 marks? No. Did he know about this, that he got 70? He may have known. That is another aspect. I'm
In
not
that
on that.
aspect also, they could have
I'm
raised
not
why
on
the
that.
mark is
He
not.
may have known. But the question is, he may have known. Like you may have known that you would get 55 if it is done with 60. You may have known. I'm not on that. But what is the rationale of having 160 marks?
That is lordship of their part lordship. They,
That's why-
but so far,
You see, getting a job of a government job is a very difficult thing.
my lord, I am admitting that the mark should be lordship in the advertisement. That is not there. But he should have raised that objection in the very inception before entering into selection process. That why the mark is not given in the advertisement, how much will be there in Viva Voce and how much will be in the driving test. He could have raised at the very inception lordship. He did not raise. After knowing that lordship, he has participated in the selection process.
He knew it that only 30 marks will be there. He thought it.
No, that is his thinking,
No,
but that is not on record.
no. His thing was, there will be only 30 marks of Viva Voce. So he has already got 70. So you have been given 40. So he will get minimum 2 or 3 also. If he gets also out of 30, then also he passes with. You cannot get 30%,
No,
30.
it is not a case that driving test and signal test marks is given. Only the Viva voce is not given. It is not that. Because neither the Viva driving
Mr.
test,
Khan, I think you are not understanding what I am saying.
Lordship, I have understood that.
He must have, I'm not saying he has. He must have known that I've got 70 out of 100. So now as per the norms, that will be 130 marks additionally for Viva Voce. So you cannot surpass him.
My lord, even an illiterate person, he may get Lordship high marks in driving test
He
and
never knew that
signal
it would
test.
be done with 60 and you will get 55. Hello.
And only your Lordship will take into consideration, he is more than 40 now. He should be allowed to participate in the process. In the process of selection. But otherwise, my lord, that has to be there, my lord. Judgment are there. If the process starts again, the petitioner has to be allowed to participate in it by condoning his age. He will be, I think, for 2 years, no, about 2 years. There, at that point of time, otherwise, my prayer was, my lord, from the point of vitiation. That is, after the driving test, all are, my lord, vitiated. So from that point, the Supreme Court judgment which I have given is lordship. Point of, from the interview should be conducted from the point of vitiation.
Point of?
Vitiation. It vitiated. Here it vitiated from the driving test, it is all right, but screening test and interview process, they will have to redo it. Driving, screening test and the Viva. This thing, they will have to redo it now.
No, he has to do it everything, zero.
Everything, my lord, in that case, your lordship will permit that he should be allowed to. Otherwise, he will lose his chance.
I think that should be, that direction should be there, because rightly or wrongly he participated. Now, for his right should not be, right of participation should not be defeated for the.
And your lordship can see the High Court's advertisement, very clear. Clean, driving test 40, screening test 40.
No, I mentioned it, it has to be all the marks. Whatever marks you are going to do it, you have to give it. You cannot later on change the rules of the game.
Yes, fine.
You can't do that. You gave him, you gave the respond number 6 appointment again, you do it, whatever may be. But the question is, you have to.
Criteria should be fixed.
This is very clear.
Absolutely.
That will take into consideration that aspect of the matter. Your lordship.
I'll be.
Timing item 5.
Mr. Borbuzai, what do you say about this particular note? Have you seen his affidavit in reply?
Affidavit in reply, yes, my lord.
What do you say about his note?
My lord,
Note number 5 to the 2017 rules.
120. Page 120.
Proviso.
yes, page 126.
Oh, no, 123.
Which section? Which rule?
Yes, my lord.
Huh? How do you take care of this?
Now,
And this has been given to the other people who were accordingly appointed. You see the notes which have been given by the finance.
yes, my
The
lord.
subsequent notes which he have enclosed.
Yes, my lord, at page 123. Application of the revised pay, same as otherwise provided in this rules, a government employee who is in service on 31st March 2016 or who may have been appointed on or after 1st April 2016 shall draw pay in the revised pay structure, payment with grade pay applicable to the post service which he has been holding or to which he may have been appointed as the case may be, provided that a government employee who is in service on 31st of March 2016 or who enters service on or after 1st April 2016, but before the date of publication of these rules may, at his option, continue to draw pay in the existing pay structure until the date on which he earns his next or any subsequent increments in the existing pay structure or until he vacates his post or ceases to draw pay in the existing pay structure.
So by this, he would not be entitled to. Now, this has been given subsequently, see the notes.
Yes,
Next, later on, what has happened? This person who were appointed together, this person is from Nagaon. The other person is from Kamrup.
yes.
He made all these things. Now, what did the finance say? Finance, kindly see the note sheets which have
Yes.
been included, the last pages. Handwritten.
Yes, matter discussed with FA on an examination of fitment table 10 of ROP 2010 and fitment table 1.10 of ROP 2017 indicate that the basic pay in respect of stenographer grade 3, which was 10,380, 7170 plus 2,900 GP plus 3110 advance increment and the rate of 3% was revised to 27,990. Pre-revised 14,000 so and so modified. In this context, the fixation of pay as done by the Registry of Guwahati High Court by the OM number so and so appears to be in order. The department may perhaps with the approval of LR inform the district session judge accordingly submitted for further orders. Now, this is.
And he has been given.
Yes, no, but this is exactly what, my lord, we have spelled out in our affidavit.
So now whether he will be entitled to.
So he is entitled to the correct scale of pay, which was informed by the finance department, my lord, to the authority concerned. Because there was an erroneous.
No, kindly see rule 5. Save as otherwise provided in these government rules.
Yes,
A government employee who is in service on 31st of March 2016
yes,
is not, or who have been appointed on or after 1st of April 2016
Hmm.
shall draw pay in the revised pay structure.
yes, he will be revised pay structure.
Okay, you see, pay band so and so applicable to the post service which he has been holding.
Yes.
Or to which he may have been appointed as the case may be,
Yes.
provided.
Yes.
Now see, provided
Yes.
that a government employee who is in service on 31st of so and so,
Yes.
or who has entered service on or after first year, but before the date of publication of these rules,
Yes,
may at his option
Yes.
continue to draw pay in the existing pay structure
yes, my lord.
until the date on which he earns his next or any subsequent increment
Yes.
in the existing pay structure or until he vacates his year. So if his case is that if he was appointed in the area of 5,200 or something to the effect which is there, if he was there, he continues by operation that he was appointed subsequently would not make any difference because of the proviso.
Look, because of the proviso, this is a note. But what is
No,
the
this is not a note. No. That is what I'm saying. You
Yes.
see, no, Mr. He has not given you the properly. Wait. Because,
provision of the notification?
No. Let me see. This is the rule 5.
Yes, this is a notification, my lord. This is a notification of 17th of March 2017.
This is the notification by which the rules have come in. This is
Yes.
the rule.
Yes, now this, my lord, rule 5.
Rule 5.
Rule 5 has
The
been,
proviso.
yes, rule 5 has been expected here. Which lordship has just now seen. Rule 5, save and otherwise, same language.
No, it is the same. So this is no notification business. So now what happened?
Yes.
That very person
Yes.
who is there in the enclosures out there,
Yes,
he has been given the same benefit.
so he,
There is no recovery made from him.
the period in which he served under the establishment of District and Session Judge Nagaon Lordship, that period he got the lower pay scale Lordship, and when he was subsequently transferred to the establishment of Kamrup Metro, he got the higher one Lordship. That has not been rectified in respect of that Nagaon Lordship establishment,
Who's yours?
that Azizul Haq Chaudhary. Lordship.
So he also is not getting it.
No, he did not get it for the service rendered under that establishment of Nagaon.
Understood. But you have got the benefit.
No, subsequently, he was transferred to the establishment of Kamrup Metro Lordship, and therein the revised one in the higher pay scale was given to him. When he joined hearing Lordship in the establishment of
No,
Kamrup.
here we are not concerned with to be given a higher pay scale to you. We are concerned you are challenging the recovery.
Lordship,
You are only challenging the recovery here.
as well as fixation in the current pay scale Lordship.
What correction pay
Yes,
scale?
Lordship. There is there Lordship.
Stated in detail, my lord, all the calculations. If I may be able to draw my lord's attention to my affidavit.
Prayer number 5 Lordship.
No, but if he is, Mr. Babuja, if he is allowed to remain in the same pay scale,
No, same pay scale cannot be. Therefore, lordship will kindly see, my lord, my affidavit at running page number 77. I will have to draw my lord's attention, my lord, to some of the paragraphs. How these, my lord, permutations and combinations work, my lord,
77.
page 77. And so far as Azizul Haq Chaudhary, my lord, there is an explanation with regard to Azizul Haq Chaudhary also, at paragraph number 5. Everything has been explained.
Now, Lordship, one thing I would like to.
Wait. You have said, let me understand.
Paragraph-
And this happened because of you. Last time I was to pass the order. You did not.
No,
And because of this is happening. I have to again refresh my mind with this.
Now, paragraph number 4, I may read it, madam. That with regard to the statement so and so, to state informed from the, to state that from the annexers to the writ petition, it is seen that the petitioner was appointed in the post of.
Yeah, others may go. You want anybody who wants any dates, you can get it, huh? Which one?
Not remaining item, I have some matters, my lord.
Item 15, madam.
Item 8, 9, 10, 11, 12, 16, 18, 20, 23. Not on next week, my lord. Some difficulty on the next week. Thereafter, we. Nine, 10. Uh,
23 you want?
My lord, 23, 20, 18, 16, 12, 11, 10 and 9.
When do you want?
Not on the next week, thereafter.
21.
Yeah, keep working. মই নাই কিন্তু। মই অকল মই মোৰ কেইটা কৰিম। 23,
And Mr. Muzumdar, your matter is which one?
Item 15, my lord.
16.
1-5.
Oh, this one, nah? Isn't this your case where I've asked them to file an affidavit as to why you have been put at later on? Isn't that the case?
Yes, my lord.
Although the High Court directed both of them were to be appointed and you were higher in the rank.
Yes.
And
I
this
was-
person
my selection
concerned had issued him earlier
Yes.
the order.
Yes, that
Affidavit filed.
affidavit they have filed, I have to file my reply in one of them. Otherwise,
You have filed affidavit in 15.
15, my lord, they have filed their affidavits. I need to file my reply in 15.
Ah.
The others, my lord, item number 17 was there, no affidavit. And item number 14, I have filed my reply.
Meeting.
Item 15 is taken up on the next week also, my reply will be on record.
He doesn't want when? You are not there in 15.
not in, no, I am not in 15.
15, somebody else will be there, na?
15, I am not there.
Chalo, you all take your dates.
Yes.
Today I gave an upgraded year to this item number 22. Who is there?
Yes, I'm here, but
Oh, you?
Yes.
Okay. We have it next week, 2 o'clock.
Got it.
Okay?
Of-
Next
of my
week on, what is that date? 15. 15.
15 May.
2 o'clock, huh? Who is there? Government?
government is financing.
Finance, Mr. Bobujari, you are there?
P Nayak is there, I will inform.
That this matter is being conducted by P Nayak.
I'll
I will
inform him.
inform him.
Fine,
Obliged.
inform him, we'll take it up at 2.
Sure.
Has the affidavits been filed?
Yes, affidavit has been filed by the finance department. There has been,
Oh, we
delay
are
has been
concerned with
controlled.
finance only. Oh,
Yes,
okay.
Lord, I'm appearing.
We'll take it up on 2 on 15th.
15.
At 2 on 15.
15. Okay,
Obliged. My lord, item number 21,
21 no, 22. 21 is what?
my,
What do you want?
only date on 29 or 29.
By 29? Let it be there next week. Okay,
My lord.
in time we'll extend it. In time to the extend ko ito next date. Give a particular date.
My lord, then item number, my lord, I'm sorry, my lord, item number 18, my learned friend has requested for the week thereafter. My lord, would it, if it is not inconvenient, my lord, could it be on 29?
Okay. Take your date. 29.
Briefly,
These matters are all Thursday matters.
Thursday matters.
Oh, yeah. And your matter is to be taken on Sunday. Because of your matter, I get confused every time. Mr. M. Sharma, earlier I made up my mind and every time you come up with a new plea.
No, Lord.
Eh? Your plea is something like a toothpaste. It keeps on coming out. Every time you come up with a new thing, it never ends. Mr. Bopujari, this matter again, I'll hear it on next time as top of the list. Next Monday, next Thursday, top of the list. No more.
They have referred it to the judicial department, Lordship, so they may also come up with some plea because the note sheets.
Don't come up with this. Whether finance, if the finance doesn't give, judicial department has no business of.
Clear, absolutely clear.
They
I have demonstrated.
referred it to the judicial
Meeting
department.
I
Yes, I will defend.
Next
I will defend. Yes,
top of the list. Kuri.
my lord. I'm so obliged.